answer that. They've requested that whatever we're doing tomorrow morning, whether it be their case, whether it be if you are calling witnesses, that we pause about 11:45 in order for the jurors, the court, and the parties to be taken to that secure location for that jury view. Do you have any position as it relates to that?
Yeah, my position was when I answered, I said, do I have to be present?
I'm requiring you to be there, yes.
And what reason do I have to be present?
Unless you're willing to go through a colloquy with this court and intentionally waive your right to be there, because then I'm going to require you to be there.
And that's not explaining why I have to be there, though.
Because I'm requiring you to be there, sir.
And you just made that decision now?
All right, he's not answering the question that I asked him. We will pause at approximately 11:45 tomorrow morning.
Don't I have rights, though, Your Honor?
All right, then with that.
Could I ask another question?
Go ahead.
Scheduling, Your Honor. We still have not received anything from Mr. Brooks as to the date and time when he would like his witnesses ordered to appear. I don't see anything was e-filed.
Mr. Brooks, we need to know which particular witnesses on which day, and whether it's AM or PM. Don't need to give me the order. We'll have them come in groupings, but it's not reasonable that they all come on the same date. So you need to provide that to the DA.
How am I supposed to provide that to the DA?
You can write that down, or you can put it orally on the record right now. I asked you to bring it with this morning, and I didn't cover that this morning, so you were put on notice of that. But I'll give you until...
I was put on notice of what?
If somebody needed to give notice to an employer and it can't be accommodated, then that may affect things for Mr. Brooks. But I think 24 hours notice is generally reasonable, and we will do our best. We can assure the court we will do our best to get them here, but I don't know if we'll be able to exactly accommodate the timing that he may or may not want.
All right, so Mr. Brooks,
Objection to that, because when the subpoenas were served to them, I'm assuming that they would have let any employers or anything know that they were expected to testify in a trial. I don't understand why it will become a problem at the last second.
by the start of court tomorrow, you need to bring with you, either in writing or be prepared to put it on the record orally, which witnesses you want. Use your best judgment on that.
Yeah, I don't know how I'm going to come up with exacts on that.
I presume you're going to prepare some questions and you might be able to kind of gauge how quickly that will go or not. If not, we'll do our best, but you've got to provide some definitiveness. It's not reasonable to just have these witnesses all come on one day.
I'm informed of what you're saying. I just feel like that same courtesy wasn't afforded to me by the prosecution. They didn't have to tell me exactly what witnesses was being called on what day and all this and that. Why is it not
I am requiring it, sir, because they are assisting you, because they graciously agreed to do that because you are representing yourself. If you want them to be out of the loop on that, then I can just put it on your responsibility and your shoulders, but that is up to you.
What do you mean by putting it on my shoulders?
You can contact them.
How am I supposed to do that?
You have access to a phone in the jail.
So I'm supposed to call everybody that I subpoenaed, not knowing their information?
That is one way to do it, sir. Their information is in the police reports.
That is highly unreasonable. When one person that's on my witness list, I'm not even permitted to have contact.
That would be a good exception to that. So that's very astute of you to point that out, sir. That would be one exception. But other than that, in any event, sir, we're kind of a bit off track. We're going to get back on track, and you need to provide the information that's provided, that I've outlined here today.
I don't think that's fair, Your Honor.
Oh, your objection is noted. It's my ruling.
The state didn't have to do that, but I have to do that.
Sir, I remind you that you are nonetheless required to follow the rules of procedure, just as any attorney would have to if they were representing you. You've chosen to represent yourself. The state has graciously agreed to assist They've served the subpoenas on your behalf. They didn't have to do that, but they did. They're simply asking for some basic courtesy, so they can then relay that information to the witnesses you want to call in this trial.
I'm informed of that, Your Honor, but
All right, then let's move on.
that's actually under the confrontation clause in the Sixth Amendment. I should be able to have a right to have witnesses subpoenaed. It shouldn't. Why is that?
Again, we're getting a little far afield here, sir. Subpoenas were provided to you. The record is very clear on that. We assisted you with that. I even reviewed them for completeness. And then the state assisted you with serving them. That is something they are not required to do, but they agreed to do in this case. So nothing about your Sixth Amendment has been violated in that regard.
Did I say violated, or did I say I'm not?
So you need to understand that, sir.
I don't understand anything, and for the record,
All right.
I didn't bring up the word
Let us
violated.
continue then. We're going to move on, Mr. Brooks. Let us continue with the
So we
questioning
gonna move on to
of.
subject matter jurisdiction that
No, we're
has yet
not.
to be proven?
Detective Carpenter, you can please come on back up to the witness stand, and Madam Clerk, you can have the jurors brought out.
So we're not gonna address that at all? That's not gonna be proven for the record? Is that a judicial determination that you don't have to answer the question, Your Honor? Is there also a tactic agreement?
The United States would move exhibit 82 into evidence at this time.
All right, you want to do that in front of the jury or just with me?
I wasn't sure if the defendant would have any objections that would need to be heard off the record, or outside the presence of the jury.
Well, can you have them hold for a second? Do you have any objection to Exhibit 82?
Yeah, I got objection.
What's the objection, sir?
What is the relevancy of Exhibit 82?
82 is your interview with Detective Carpenter and Detective Stern. Your objection is to relevance? Your objection's noted, it's overruled, and I will receive Exhibit 82.
The court will let the jury know that when they
So
come in.
are you
Yes.
overruling the fact that the true nature and cause has not been presented to me, that I don't know what the true nature and cause of the charges are? Your Honor, may I see a sworn affidavit of the nature and authority of the court? Or is that a judicial determination? You won't answer that as well?
Welcome back, ladies and gentlemen of the jury.
The record reflects that.
The record will reflect that Detective Carpenter is back on the witness stand following the break for the lunch hour. And Mr. Brooks, you may start your cross-examination.
I don't consent to being called that name, Your Honor.
Your objection is noted, it's overruled. Please ask your
Can't be
questions.
overruled. Detective Carpenter. Did you attend the parade that evening, November 21st of 2021?
Yes,
What time did you leave?
I don't recall the exact time.
And when you left, where did you go?
Our temporary police department,
Temporary. Explain what do you mean by temporary?
so at the time of the incident, the building we are in currently, which was our main building, was under construction, so we were displaced.
What were you guys using for the temporary police station?
The city annex and city hall, we're in two different buildings.
Does any of those buildings consist of a room for interrogation?
There is at the annex.
And so when you initially interrogated the suspect, why was the annexed interrogation room not used?
Well, when I interrogated you, Mr. Brooks, the annex room was not used because the situation was very fluid. There was a lot of information being learned. We knew this was going to be drawn out. There is no municipal lockup facility at the annex, so it could not be utilized.
And so the police holding room in the hospital was more sufficient.
You asked to go up there for medical clearance.
Why would a hospital police room be more sufficient than the actual police station that you were utilizing at the time?
You requested medical clearance at the hospital.
So was there sufficient lockup at the police room in the hospital?
We had areas in the hospital, so when you were being treated by the doctor, you could be handcuffed to a bed.
How come the suspect couldn't be handcuffed at the annex for the interrogation without having to be handcuffed to a specific bench or whatever you refer to it as?
Well,
I guess essentially what I'm asking is, could the suspect still be properly detained while being interrogated at the annex versus the police holding room in the hospital?
so let me make sure I have this straight. The question is about detainment. Do I have that right?
I think the question was very clear, Detective.
I can't answer it if I'm not going to get clarification.
And where was the suspect taken upon being detained?
You were taken, Mr. Brooks, upon the time you were arrested, down to the substation on Les Paul Parkway in Waukesha.
Do you recall what information was obtained at the substation?
Yes?
Do you recall what that was?
Yes?
Can you state for the jury and for the record what information you obtained at the substation?
Yes, sir. Basic biographical information. So I obtained your first name, Darrell Brooks, your last name being Brooks, your full middle name, I should say, being Edward. I learned that you were a junior, the date of birth, February 21st, 1982. Additional information obtained was your home address, which was you provided as 4014 North 19th Street in the city of Milwaukee. Phone number, your emergency contact, which you provided as Dawn Woods, whether you were employed, going to school.
Kept mentioning that name, pretty slick.
Sure, disregard that last statement, sir. Please ask questions. You'll have an opportunity to testify later.
Oh, I got a lot of questions. And at that point in the investigation, what did you initially know?
At that point, we knew that the red Ford Escape had driven through the parade route and that you'd been identified as a suspect.
And why was that information not provided at that time to the detainee?
The information at the time wasn't presented to you, Mr. Brooks, because, as I stated in my earlier testimony, it was very chaotic out at the scene. There was still a lot more that needed to be learned.
So is that standard procedure to not tell a person why they're being detained?
Well, we did not tell you. That's incorrect, and it's misleading to the court. You were informed you were being detained for prowling, littering, disorderly conduct of that nature.
Is that the same as...
Can I finish, please? I just didn't bring up the parade part of it.
Why not?
As I stated in earlier testimony, it was very fluid and chaotic, and a lot of information wasn't yet known. So I was waiting to receive more information.
Did you state in your early testimony if that was standard procedure or not?
It's standard.
So with every detainee that you've ever detained during your career, 18 years, right?
Yes.
It's standard procedure to not tell someone being detained what they're detained for.
As I stated in my earlier testimony, Mr. Brooks, I explained to you you were detained for prowling and loitering and disorderly conduct. Based on the lack of information on the parade, that was not brought up. So what I can clarify for the court at this point is that in situations where so limited information exists early on, it is standard not to convey that information to suspects.
And what do you mean by it's standard?
I mean that I don't tell them because I don't have all the facts yet, and I'm not looking to necessarily accuse them before I know the nature of what they did or didn't do exactly pertaining to that incident.
So it'd be fair to say that it was not a fact as far as the information you learned to that point in the investigation.
Objection then.
Grounds.
Sustained as to the form of the question.
So at that point in the investigation, it wasn't a fact.
Objection, same question.
Grounds.
Sustained as to the form of the question.
At that point in the investigation, the information you had at that time, you weren't sure about.
I guess which part?
All the information that you had up until that point.
Okay, about the prowling or parade, I don't understand which part of it you're talking about.
All the information that you've obtained at that point in the investigation, you weren't sure about. As you just said, you don't try to assume guilt or anything like that until you have all the facts. So at that time, at that point in the investigation, is it fair to say that the information that you had obtained so far, you were not sure about?
I wasn't sure if you were the driver initially, but it was believed you were involved.
And you knew that to be fact?
Yes, the information being provided was that you were involved.
So it'd be fair to say you knew that as a fact?
Well, hold on, I'm gonna not allow him to answer that. This jury will determine the facts of this case. If you want to ask him his opinion, you do that at your discretion.
He said fact. He said facts.
You asked the question, sir, so
But he brought it up first.
I'm going to strike the question from the record, and Mr. Brooks, you're directed to rephrase.
I will rephrase, but I do not consent to being called the name for the record. So why did you constantly tell the detainee that they were being detained for loitering and prowling if you in fact knew that there was another reason why they were being detained?
Objection asked and answered.
Sustained. That's the form of the question.
What was the significance of the FBI being present?
The significance of the FBI presence was the early on concern that this was a terrorist style event.
And you said that this was a terrorist element. And what is the this? Can you explain what the this is?
When you drove your vehicle through the parade and struck people.
Which at the time you stated you did not know is fact, correct?
That was still being investigated, yes, but I know that's what occurred now.
Now versus then.
Initially, it was unknown if you drove.
That's what I was
stated.
That was the question.
But the investigation showed that you were the driver of the vehicle.
And initially you didn't provide that information, correct?
Correct.
So do you know if the FBI continued their part of the investigation?
Eventually, the investigation was strictly run by our department.
And do you recall why that decision was made?
My understanding is there wasn't a terrorism link.
You made reference to car key being found. Do you recall that?
Yes, I do.
Did you yourself find the car key?
No, I did not.
Were you told by other law enforcement?
I guess told what exactly?
That a car key was found?
I was not specifically. Your items that were located on you during the search were turned over to Detective Stern, and the car key was one of those items.
And to the best of your knowledge, you didn't have that information at the time, correct?
At which time?
At the time that the detainee was detained in the substation.
I just want to make sure I guess that I understand. So you're asking me what I knew about the key, or if I knew where it was found at the substation? I don't understand.
I guess the clarity that you may be looking for is what was found and brought into the substation?
Okay. The Ford ignition key and other items that I alluded to in my earlier testimony include your photo ID and credit cards with your name, or debit card, credit and or debit cards with your name on them.
That you did not search and find yourself, right?
That's correct.
So it'd be fair to say you don't know where certain items were found at the time that you learned of there being items found, correct?
No.
No, as in?
No, I knew those items were found on you in the search. Maybe not the specific pocket, but I knew the officers found those items in your possession.
Were you at the scene of the search?
No.
So how do you know where they were found?
Because they were turned over to Detective Stern as your property.
How do you know where they were found, though, if you weren't at the scene?
Because I was aware officers searched you, and it's not reasonable to believe they were randomly in the grass at the house you were at in a city that you've indicated you're not familiar with.
Can you strike that last answer from the record? I didn't refer to any house, grass.
You asked an open-ended question. His answer will stand. Your request is denied.
So it'd be fair to say that in the question, I did not mention a house, grass, or city? That'd be fair to say?
You didn't mention it, but I know you were found at a house in the city of Waukesha. And I know you're not familiar with Waukesha because that's what you told me when I interviewed you.
Can you strike that last answer?
Request is denied.
On what grounds, Your Honor?
You asked the question, he answered it. If you want to limit, ask leading questions and direct him. That is your right during cross.
You made reference to the house where the detainee was found, the grass, the city. Could it be possible that that's where they were found? The items that you are referring to?
No.
Even though it'd be fair to say that you were not present.
Correct.
You made a lot of reference to the body pain and having to be checked at the hospital and being medically cleared. Would that be fair to say?
Yes, we took you to the hospital for clearance.
Are you yourself a doctor or have any training in the medical field?
No, sir.
So it'd be fair to say that you cannot know how a person's body is feeling. That'd be fair to say?
I can't explain exactly what another's body's feeling, correct.
So it'd also be fair to say that there's a possibility that you can be incorrect about assumptions made to pain reference. That'd be fair to say?
I think that depends on the circumstance. In this specific circumstance, you told me.
The last follow-up, if he wants it.
Okay.
You made reference to the FBI being present because you were short-staffed. Do you recall that?
I don't recall exactly what I said, but I recall acknowledging their presence, yes.
You would like the audio recording from the hospital.
Yes, Your Honor.
Do you want it started right at 4:25?
Yes, Your Honor.
I'll tell you.
Darrell?
Yes, sir.
I'm Jeremy Wojciechowski. I'm the FBI.
FBI.
Yeah.
FBI.
I'm
Mary, yep.
They're just kind of helping out because we're so short-staffed tonight. So, thank you.
It's paused at 4 minutes and 56 seconds. Go ahead.
From hearing the audio on this exhibit 81, do you recall saying that the FBI was present because you were short-staffed?
That is my voice. I don't recall saying it in the moment, but that's my voice.
That is your voice.
That is me talking.
Do you recall being short-staffed at that time?
Yes.
And can you explain what the short staff mean as far as at that time, what would short staff mean?
That we were just very short on resources with what happened down at the parade route and the mass casualties and the amount of officers it took to secure that location. We were very short on people.
And you
People were
made
calling off
reference,
duty.
you made reference to the short staff being the reason why the FBI was present.
Yes.
Is FBI usually present in the situation of short staffing?
No.
At some point, the detainee was moved to the Muskego Police Department, correct?
Yes, you were moved to the Muskego Police Department later in the evening.
And when did you learn that that would be a location that the detainee would be going to?
After the first interrogation attempt.
First interrogation attempt. How would you define attempt?
I read you your Miranda rights verbatim from the Waukesha Police Department Miranda statement form. And at that time, you indicated you didn't wish to speak with me.
So it would be fair to say that the Fifth Amendment right was exercised at that point.
Right to silence.
Under the Fifth Amendment.
Yeah.
So, acknowledging now the fact that the Fifth Amendment right was invoked not to speak, or as you say, the right to silence, why did you continue to record on your phone?
So we are trained at our police department, when you do an interrogation, the recording is to be left on pretty much until you try to effect transport.
Even once a detainee has invoked their right to silence, you still continue to record? Is that a standard practice of your agency?
Yes, it is, for as long as they remain in the room.
And so when did you start recording?
Prior to you entering the room.
So you started recording before the detainee entered the room, and you said you keep the recording on until they leave the room. So would it be fair to say that there should only be recording while the detainee is in the room?
No.
And you did say for the record that that's standard procedure in your agency.
In regards to the interview rooms at our normal police department, which wasn't available at that time, yes.
Would it be fair to say that you were not at the normal police department?
Yes, however, with the audio, I was still trying to make sure I followed the policy to the best of my ability.
Can you show proof of that policy?
I don't have it.
So it'd be fair to say that there's no way to determine if that truly is policy if it can't be proven.
Objection, argument.
Grounds.
Sustained as to the form of the question, it's argumentative.
How can that policy be proven?
Objection.
Grounds.
Sustained on relevance grounds.
Do you know where that procedure is located in your agency rules?
Objection, relevance.
Sustained.
Grounds for the sustain, Your Honor?
Relevance grounds. Relevant. Not relevant. Next question.
It's not relevant?
No, keep going. We can take it up later outside the presence of the jury at our afternoon break, but for now, keep going.
You stated to being present during the booking process into the Muskego Police Department. Is that fair to say?
Yes.
So why couldn't interrogation be conducted at that time, which would have been more ideal considering that you said there was a lockup. I forgot how you referred to it, but basically like a room that the detainee could be secured.
Well, you had been talking about at that point when we arrived at the facility with you that you hadn't eaten all day, you hadn't slept, so we wanted to give you an opportunity to eat, sleep, clear your mind, and refresh yourself.
And what bearing would that have on interrogation?
Well, I mean, you said you hadn't eaten, you hadn't slept. So I think a person is more focused when they're fed and they're rested. So, you know, we wanted to give you the opportunity to do that.
In your opinion, how would that have affected interrogation?
I'm going to excuse the jury right now. So if our jury, we could stand for the jury so I can take up a legal issue, please. So I'm going to take up two issues right now. One is when I paused earlier and told Mr. Brooks I would allow him to, it was regarding the policies. I want to know, as the proponent of the evidence, why you think that's relevant. And then secondly, the questions I believe that you are asking related to the interrogation, unless you can convince me otherwise, go to a legal issue that this court has already determined. But I'll hear you out on that. The
Policies. That's relevant because I think it should be stated for the record why he left his phone recording after he acknowledged that the Fifth Amendment right to silence had been invoked. At that point, interrogation is supposed to stop completely.
Well, I understand what you're saying from a legal perspective, but why do you believe having a specific policy and him testify about the specific policy is relevant to his testimony?
Well, I believe that if that's in fact the policy, it should be proven. It should be proven that that's a fact, that is a real policy. For all we know, he could just be saying that it's a policy. And at that point, it makes him continuing to record after the Fifth Amendment had been invoked.
Well, right now, you assume facts that are not in evidence.
If he's saying that this is a policy of his agency, he should be able to prove that that's policy. Because at that point, if there's no way to know that that is the correct procedure that they use every time, then
You're
why?
again making a lot of generalizations that I don't think are accurate as to what he said. This is a trial, sir, where the allegations in this case are that you drove through the Christmas parade, right, and caused death and injury to a number of individuals. There's also those other charges related to the bail jumping, the battery, and frankly, his conduct isn't on trial. We're not here about a police misconduct trial. I'm not saying that some of this information might not be relevant to his credibility, things of that nature, but you have to, again, you're the proponent of this. Why do you believe those policies relate to an issue of fact in this case or otherwise go to your defense?
I believe that is relevant because it can show that at the very minimum, that first interrogation and anything related to it should not be admissible as evidence.
I've already ruled on the admissibility. That's a legal determination. So I'm not seeing the relevance to those specific policies, and there is simply no requirement that the state or this witness has to prove those policies. You are representing yourself. Hold on, let me finish. You're representing yourself. I'm not aware of any subpoena that required him to bring those policies with. So that would have been on you if you felt it important to cross-examine him on those policies to require that. I'm not aware of that. Have you done that?
Obviously, it was going to come up.
Did you issue a subpoena ducis tecum to this witness to bring with any of his policies related to interrogation?
How can I do that myself, Your Honor? How can I do that from a jail cell?
You were given all of those blank subpoena copies, sir, and you could have filled that out in a way for this witness to require. You didn't do that.
So who would have served him?
The state would have. They served your other subpoenas, so I'll give you one more opportunity. Why do you believe that questioning him about the policies are relevant to your case?
It's relevant to the case because why would he be recording before people are even in the room and then after?
Well, that's argumentative, sir, so that's not a legal basis.
Once the Fifth Amendment is invoked, interrogation is supposed to stop, period. There's supposed to be no more recording, no more questions asked. That should be the end of the whole interrogation.
These are legal issues that you're trying to raise before the jury. I've already dealt with the admissibility, so you've not provided a legal basis to further question this officer about policies related to the interrogation and the recording.
Do you recall making a statement that we all know how women can be? They're crazy?
I do.
And what did you mean by that?
It was just additional rapport building that I've talked about in my earlier testimony. Speaking to you on a person-to-person level, quite honestly, it wasn't a judgment I generalized towards all women in the world. It was just wanted you to feel comfortable talking to me as a person. I felt we had rapport. I felt I could tell the night before you were comfortable speaking to me. And it was just a continuation of that.
Why did you feel that would have been necessary to build a rapport that you stated that you already felt that you had?
And I was just continuing to go along those lines. It wasn't anything other than to just communicate with you on a stiff level, relaxed level.
And do you feel, would it be fair to say that other comments could have been used to keep the detainee at ease?
Objection made.
Grounds.
Sustained as to the form of the question.
Was there any other conversational tools you could have used to keep the detainee at ease?
Objection.
Same.
Grounds?
Overruled, the witness may answer.
Perhaps, maybe.
Would it be fair to say that you felt that at that time, the conversational tool that you used would be more appropriate for the situation?
I don't know that I was really thinking about appropriateness. Like I said, I was just conversing you on a normal person-to-person level was my intention at the time.
So it would be fair to say that you assumed that that would put the detainee more at ease by starting the conversation with along those lines?
That's not anything that I did just specifically for you, Mr. Brooks. I always want people to be as relaxed as they can be. I want them to feel comfortable to talk to me if they are willing. It doesn't change the fact that ultimately I have to read Miranda.
Speaking of Miranda, do you recall reading the Miranda rights in the second interrogation?
Yes, I do.
Do you recall how long into the interrogation before you read the Miranda rights?
Objection.
Grounds?
Objection, misstatement, and mischaracterization of the evidence.
Grounds.
Well, sustained is for the form of the question.
Do you recall when in the second interrogation you read the Miranda rights?
Your Honor, I am going to object again to the form of the question. The interrogation began, the court made a finding as to when the interrogation began prior.
I'm going to sustain the objection as to the form of the question. It calls for a legal conclusion. Next question.
Did you immediately start the second interrogation with the reading of Miranda rights?
No, that is not the first thing I stated to you. First, I explained to you what I was wishing to talk to you about.
And do you recall how long you were in that explanation phase of the interrogation?
Maybe around 15 minutes, 16 minutes.
So it'd be fair to say that you didn't read the Miranda rights till somewhere after already interrogating the detainee for 15 minutes at least.
Objection.
Grounds.
Misstatement.
Sustained.
Had you spoken with Ms. Patterson about the alleged domestic allegations?
I did not.
So it'd be fair to say that you, at that time, didn't know if they were true or not?
No, that wouldn't be fair to say.
And why would that not be fair to say?
Well, hold on. It's for this jury to determine the facts of this case, including the domestic allegations.
Is it fair to say that someone who is being detained would perceive that as being misleading when there's two different reasons why they were being detained that was told to them?
Objection, speculation. This witness cannot know what is in someone else's mind.
Calls for speculation.
At any point in the interrogations, did you knowingly lie about the information that you had?
There was information I withheld from you, yes.
So it'd be fair to say that you lied.
Objection.
Mischaracterizes this officer's answer.
It's argumentative, sustained as to the form of the question.
Just for the record, there is a point in there where you
Sustained
stated that he
form of the
lied.
question.
Why did you continue to withhold information repeatedly?
Interrogation doesn't truly begin until I'm asking you incriminating questions potentially after you've agreed to waive your rights and speak, something you didn't do on the first day. On the second one, quite honestly, it goes back to what I stated in my earlier testimony. I wanted to make sure the information I was getting from you was truthful. I wanted to make sure that I didn't lead you down a path of potential lies. And third, quite frankly, Mr. Brooks, I didn't believe if I gave you the information you were going to tell me anything.
You made reference to the first interrogation saying that there was no There was no waiver of that interrogation?
Objection.
I'm referring to what he just said at the beginning of the answer.
I'm gonna sustain the objection. Next question.
Grounds for the sustain?
Next question.
Grounds for the sustain, Your Honor?
Next question.
So I can't get no grounds. Okay. So you made reference to not being sure if you wasn't sure if you were going to get the information you were seeking?
Correct.
And is that what led you to lie about the information you knew?
Objection mischaracterizes the testimony.
Grounds.
It's argumentative. Sustained.
Did that lead you to not be forthright about the information you knew?
Objection. Argumentative.
Sustained as to the form of the question. His words were that he withheld. May,
That led you to withhold information that you had obtained?
Well, again, as I've stated in prior testimony, strong part of the reason I withheld information is I wanted to gauge how honest and truthful you would be. I think it's important to know you lied to me, and this was proven by evidence about your mother owning a vehicle. You lied about coming out here in a tan, possible Kia. So there were lies that were told at this point. You lied about being body slammed by officers.
In reference to the second interrogation, in reference to finding the phone, did you ever find the phone of the detainee?
You're asking if I personally did?
Yes.
I didn't, no.
Do you recall where the phone was recovered?
In your vehicle.
When you say your vehicle, who are you referring to?
Your mother's red Ford Escape that you were driving that day.
So it'd be fair to say it wasn't my vehicle, as you stated.
Objection. Argumentative.
Grounds.
sustained as to the form of the question.
And there was a point in the second interrogation when you were attempting to show the detainee a video, almost as if you was forcing it in his face. What were you attempting to show the detainee?
I was attempting to show you a video of when you drove your vehicle through the parade route.
Any reason why you were being so forceful in trying to do that?
Well, I felt it was very important for you to see the damage that was caused from the incident. And Detective Stern made the statement as well. You were asking for more information, so we attempted to show you more information.
The night of the arrest, when did you arrive on scene to Elizabeth Street?
Shortly after you had been taken into custody.
And when you arrived, what did you see?
Can't recall exactly. I believe you were already in the back seat of a squad car.
So at that time, the suspect was already detained.
You were detained.
Suspect was already
Suspect is you, Darrell Brooks.
detained. Can you strike that last comment?
That was his response. It will stand. All right, thank you. Please have a seat.
Do you recall Mr. Brooks' questioning of you with regard to the recording made by your cell phone at Waukesha Memorial Hospital during the first meeting with the defendant?
Objection, I don't consent to being called that name.
Noted, overruled, the witness may answer.
Yes, I recall.
Are you familiar with the term excited utterance?
Yes, I am.
Objection, leading.
Overruled, the witness may answer.
What is that?
It's when an individual, whether it be Mr. Brooks or any individual, begins making statements on their own accord in not response to a question. Typically, an utterance may reference why they're in custody in the situation that you were either questioning them about or preparing to question them about.
Is it important to capture those types of utterances on tape or recording?
Objection, speculative.
Overruled, the witness may answer.
Yes, it is.
Would that be a reason to continue recording after an interview's been ended?
Objection, answered that already.
Overruled, the witness may answer. It's redirect.
Yes, it would.
Did the defendant ever tell you that there was anyone in that car other than him driving it and possibly Erica Patterson?
Objection, leading the witness.
Overruled, the witness may answer.
No, he did not.
And finally, you've been a law enforcement officer in Waukesha County for approximately 18 years, is that correct?
Yes.
Who makes the charging decision when deciding what charges get issued in a criminal case?
Objection, leading.
Overruled, the witness may answer.
The prosecuting attorney at the Waukesha County District Attorney's Office.
You don't decide on the charges?
No.
Objection.
We can forward what we believe is appropriate, but we don't ultimately make the decision to charge.
So when Mr. Brooks asked you, what am I being charged with? Did you have any ability to tell him that?
Objection, I don't consent to being called that name.
Noted, overruled. You may answer the question.
No, ma'am, not with 100% certainty, no.
Nothing further, thank you.
All right, thank you. All right, thank you, everyone. We are in recess. We'll see everyone at 8:30 tomorrow morning.
Good morning, Judge Sue Offer, Leslie Basie, and Zach Woodchow will appear on behalf of the state of Wisconsin.
Sir, would you please state your name for the record?
I'm here as a third party intervener in that matter, appearing as authorized representative for my client. I accept the value and return to value all of the charges in this matter and make my exemption available for discharge of all obligations and charges connected with this case. I do not dispute any of the facts in the charging instruments, and for the record, I do not consent to being called that name.
The record should reflect that the individual known to this court as Darrell Brooks is present in person in custody. He is in street clothes, wearing a suit and tie and a mask.
I don't consent to being called that name, Your Honor.
I understand.
For the record.
And I have advised you previously that I will continue to refer to you at times by that name, as I believe it's appropriate given the charging instruments in this case. And other evidence now that's been received during the course of this trial where I believe we are using the accurate name. With that, I don't
agree to that, Your Honor, or consent to that.
Your lack of consent is noted. As I told the parties on Monday, I had excused one of the jurors for a health reason. And it has come to my attention that I now have a second juror with the same health concern. Out of an abundance of caution, I am going to bring the jurors out to question them about their, whether any of them have any concern about continuing to serve on this jury, given the health concern. I am referring to a COVID concern.
Your Honor, will we be addressing subject matter jurisdiction?
No, not at this time.
It still has yet to be proven for the record.
I don't know if the audio is on, but
I wanted to make a record in open court and to ask each one of you if any of you have any concerns about continuing your service in this case due to exposure to COVID. And so I'm just going to go through, first of all, juror number 11. Do you have any concerns about continuing your service in this case, specifically related to COVID?
No concerns.
All right, thank you. Let me actually go back to, would the fact that you may have been exposed in any way interfere with your ability to pay attention and ultimately render a verdict in this case?
No.
All right, juror number 48, if you could also answer those two questions.
No concerns, both ways.
All right, and thank you. Juror number 46.
No concerns.
Thank you. Number 34.
No to vote.
Thank you. Juror number 27.
No, also to vote.
Juror number 30.
No concerns to vote.
Thank you. Juror number 1.
No concerns to vote.
Thank you. What's your number? 6. Juror number 6.
No concerns to vote.
Thank you. And juror number 14. I'll just start there.
No concerns to vote.
Thank you. Juror number 10.
No concerns to vote.
Juror number 51.
No concerns to vote.
Thank you. Juror number 45.
No concerns to vote.
Thank you. Juror number 19.
No concerns to vote.
Thank you. Juror number 41.
No concerns to vote.
Thank you. And juror number 3.
No concerns to vote.
Thank you. I'm going to excuse the jurors then, and then when we're ready, we'll have you brought back out. And thank you so much. So, unless there's anything related to that, I have a couple of other issues I need to address this morning.
I got something for that. The person or the two people rather that are having the COVID concerns, I know you said you wasn't gonna ask them, had they test positive or the results of any testing. Do you know if there has been exposure on their end to COVID exactly, or is that just a caution thing?
My understanding is that I've had 2 jurors test positive throughout the course of this trial. And I make a further record that they're the only one within 6 feet of each other. Obviously, you're not within 6 feet of any of them, but that's a good question to ask, and I'm glad you asked that, and I wanted to make a record of that as well.
Yeah, that would be my question to it. I guess in reference to me myself just having the same concern a few weeks ago. So that would be the reason why I would want to know exactly any details that could be provided.
I'm providing all the details that I will. Again, for the record, you have not been exposed, from my opinion, because of the distance that you are away from them, and my understanding based upon my review of county policy.
The entirety of the jury, though, have they been exposed in any way?
I don't know the specifics because of the 6 foot, right, rule, and no one has asked me to investigate that further.
Wouldn't it be smart, though, to see?
I don't believe that's necessary under the circumstances.
Well, if anything, just for future reference, like, what if it plays a part later on?
Well, I'll certainly take your concerns under advisement, and if I believe any further questioning needs to be done, I'll do that. At this point, I don't believe it needs to be done, but I'll think about that, and I'll take it under advisement, and if I change my mind, I'll let you know.
Yeah, I'm just saying, because if anything, it probably would be smart for the long run to make sure no one else was compromised, considering that.
Let me make a record there. No one has indicated they are compromised. I don't think we can make assumptions about how anyone who's been exposed or tested is feeling. You can be asymptomatic and test positive. You can have mild symptoms. I trust my jurors that they would report if they're not able to sit through the proceedings.
Seemed like the circumstances were different when it was me. Just saying.
Are you making any specific requests given this information?
Well, I believe that the jury clearly all congregate together. I think it would be smart to make sure everybody is tested. I mean, that's it would be smart to do that.
I'm not going to mandate testing for the jurors. That much I can tell you. So that request is denied.
And the grounds for the denial?
I'm not going to mandate that the jurors be subjected to testing. They're the ones who indicated they are comfortable being here. They don't have concerns. And again, I would trust them to report to me if anything changes.
I'm quite sure though that all the jurors Monday said they didn't have any concerns as well. And then now today, someone else, same thing being said. I just feel like it's smart for them to be tested. So it doesn't come up again in the future, or potentially come up again in the future, because then we'll all be looking back and saying, well, we could have prevented something like this from happening if we had just nipped it in the bud from the get-go. It's just smart to, like you say, err on the side of caution.
I appreciate that. I'm going to continue. I understand what you're saying. But given the responses of the jurors today, I'm going to continue. I want to talk briefly about the jury view. I did provide the parties with a proposed instruction. Before I get to that though, Mr. Brooks, I have been thinking about your request yesterday. And I know I indicated to you that I would require you to be there. I've rethought that. I've had the overnight to really think about it. And if that is your decision to not be present for that, what I would say is this. I want you to be advised that you have a right to be at that jury view. Did you hear me say that?
I was still confused about why did there even need to be a jury view? That was my whole thing. I don't see the relevancy of it. And I also didn't agree with or consent to having to be part of something that I don't see as relevant.
I appreciate you making a record of that. Do you want to be present at the jury view of the vehicle?
I don't see the reason why I would need to be present.
Well, that's my question to you though, is do you want to be present for it? You are the accused in this case. You're the person who the state has alleged committed these acts. The jury view will be to view a piece of evidence that frankly can't come into the courtroom due to its size. And the jury's going to be shown that. So do you want to be present at that?
For the record, I'm not a person, I'm a human being. And no, I do not consent to or agree to being present at a jury view.
All right, then I'm going to honor his request.
If I have a right to be present, then I have a right to not be present. How can this take place if I don't agree or consent to being present? How can it even still take place without me?
It will take place, sir. I'm just going to honor your request not to be there.
I'm asking a question though. How can it take place without my consent or agreement?
If you don't, it's going to take place. That's how I'm going to answer that, sir. So you not going there is not going to prevent it from happening.
My Lord,
But you can forfeit your right to be there by your conduct. And by your conduct, by not answering my question, by saying I don't want to be there and I don't consent to it, you will be forfeiting your right to be present and essentially waiving that.
Doesn't I have to sign something for it to be waived?
I don't think so in this case.
Well, yesterday you said something about
I know I said that, and I've had some time to think about that further, I don't believe I need to take a full waiver with you signing anything or even agreeing to the waiver.
So why did I have to do that for when my
I'm not going to answer those questions because that would be for me to give you an explanation of the law.
No.
I'm just going to tell you that I'm not going to require a written waiver from you in order to honor your request to not be at or even if I phrase it, your lack of consent to the jury view.
And is that lawful law? Because
Sir, I'm not gonna go through all the law that applies to that.
The way
This is my ruling. If you disagree with it and ultimately there is a conviction, you can raise that on appeal. But
No,
your lack
Your
of
Honor.
consent is not going to stop the jury view. It's going to happen. It's a piece of evidence that I cannot physically fit in this courtroom. It's too big. There's no way to get it in.
okay, I'm informed of that, but at the same time, if I haven't signed any waiver, how could it be lawful? I haven't given consent or agreement to a jury view. I haven't waived any right. When the whole issue was brought up, on the record yesterday, my first thing that I said was, I don't see the relevancy of why there should even be a jury view. And that was the whole issue. And yesterday I was told about I don't know how you say it, the colloquy or however you say it. I don't know how to pronounce it.
I know
Which
what
was-
I said, and I'm
Yeah.
telling you, I had time to reflect. That was my initial reaction to your statement yesterday, but I've thought about it some more and I'm changing my mind. You either cooperate with that process or you don't.
The way I interpret the law, though, Your Honor, which the law is designed to be interpreted by the people. The way I interpret that is I have the right or essentially to be there or not to be there, and it still has to be an agreement or consent. That's how I interpret the law.
My ruling on that, sir, is I disagree with you. You do not need to provide consent for the jury view to happen. Your objection is noted for the record. I'll make a specific finding today that it is relevant to these proceedings, to this trial. There is an allegation that you drove through the Waukesha Christmas Parade on November 21 of 2021, driving a red Ford Escape, killing 6 and injuring dozens more. So there's clear relevance of this vehicle and has evidentiary value. Again, your objection is noted for the record, but I will and am permitting the jury view of the vehicle. With that, I'm going to move on to the jury instruction.
I don't agree and consent to that, Your Honor.
I understand your objection is well noted for the record. I need to keep going though. On the pattern and jury.
I'm informed that you need to keep going. I'm not trying to stop you from continuing to go. I'm merely stating for the record that there are things I do not understand how they're being permitted versus the Constitution. I mean, I'm sure you're aware under Article 6, Chapter 2 about the Supremacy Clause, that the Constitution is the supreme law of the land. So how can we disregard?
Mr. Brooks, I'm not disregarding the Constitution. Here's the thing, I've made my ruling, okay? Once I've made a ruling, I do expect that even if you disagree with it, you will not continue to argue it.
It's not
That
arguing.
we will continue on with the next
I'm seeking to
topic.
understand, Your Honor. It's not an argument.
Mr. Brooks, I'm not going to explain further other than what I have done, my ruling. My ruling stands. Now, I'm going to move on to the jury instruction. I gave the parties
May I
2
respectfully
documents.
reject that ruling and take exception to that ruling?
Your objection is noted. I'm
For the
moving
record,
on
may
to
I
jury.
request a legal and factual basis for your
Mr. Brooks,
ruling, Your
please
Honor?
don't interrupt me, okay? I give you an opportunity to raise your objections and to make your legal arguments.
raising
And then I make a
objection now.
ruling, and then you start in on something else. You need to give me your argument all at once. For you to interrupt me afterward is disruptive to me.
It's not
And
disruptive.
it's interrupting and it's disruptive.
It is definitely not
Well,
disruptive.
if that's my view of things, sir, and what I'm putting on the record is that it does disrupt what I'm doing and the flow of what I'm doing and needing to move on, having to interrupt what I'm doing so that I can address that once again. Please, please. I know you may not always agree with my rulings, but I'd ask that you show the courtesy and decorum that is expected of everyone. And once I make a ruling, we're going to move on. You don't need to keep objecting because your objection's already been noted for the record. I'm going to continue. We're gonna look at jury instruction 152.
Well, I still-
I gave the parties 2 documents yesterday. One was the pattern instruction, which I've modified, and then one is the draft of, and Mr. Brooks, please stop. You're continuing to talk over me.
Because
You're interrupting.
You said I have the right to object, and you didn't let me even get to the objection.
I did, sir.
No, you
Okay?
didn't. I was right
Your
in the middle of
objection
it.
comes before the ruling, not after. Once I make a ruling, we're moving on.
You made a ruling before we even finished the conversation, Your Honor. With all due respect,
Brooks,
before
please
we
stop.
even finished,
That's not true, okay?
you
It's
said
not
I'm gonna
true.
make a ruling. As soon as you even started in about
Mr. Brooks, I'm not
having
gonna
the time to
spend
think.
hours on end making a ruling about a jury view on something I've already decided, all right? So please, I'm
Well-
asking you to stop. Stop
No, this-
interrupting me.
You
And
can't
please
just
listen.
disregard the United States Constitution, which has a
I
supremacy
absolutely am
clause.
not disregarding the
You are.
United States
You're
Constitution
not
or the
honoring your oath
Constitution of
office.
the state of
Your Honor, are you not
Wisconsin.
a public servant?
Okay, Mr. Brooks, you're starting to cross the line. You've already crossed it, but I want to keep going. I want
didn't
you in
cross
this
any line.
courtroom. But if you keep interrupting me and putting you on notice that you run the risk of being forfeiting your right to be present in this courtroom and continuing in the next courtroom so that I can effectively and without interruption continue with the proceedings this
So again,
morning.
you're holding me in contempt.
All right, jury instruction 152, has the state had an opportunity to review
Is
it?
that a judicial determination that I'm being held in contempt?
Instead of referring it as being in the Waukesha County Jail, I just suggested a garage attached to the Waukesha County Courthouse. I think that is factually accurate and would dispel any concerns about anybody being in custody or reference to a jail setting.
All right, why don't we print that off so that Mr. Brooks can review that as well?
Since being called that name, what do I need to be reviewing?
The state has submitted an alternate proposal for instruction 152.
And that's referring to this quote-unquote jury view?
Yes.
I accept for value in return for value this document. Now, I'd like the record to reflect, I still haven't received my original copies of my filings here this morning.
Let me know when you've had an opportunity to review it if you so choose.
I just stated for the record, I accept for value in return for value the document.
Do you have any position on the state's proposal?
I'm still trying to understand the whole process.
Mr. Brooks, my question to you is, do you have any position on the state's proposed jury instruction? Otherwise, I'm going to rule on their request.
You're gonna rule on the request anyway. I got a lot of questions that don't get answered.
I have to rule on the request, sir. It's been a proposal filed with the court.
You haven't ruled on subject matter jurisdiction yet.
Yes, I have.
No, you
In
haven't.
any event, do you have a position on the jury view, sir?
Yeah, what about subject matter jurisdiction?
One last time, Mr. Brooks, do you have a position on
Can
the
I
state's
go over the
proposed?
document, please? Can I do that, Your Honor? Respectfully for the record, may I do that? It seemed like the same thing that was there yesterday.
It's not. There are some changes.
What changes?
Reference
It's
to
the same.
the-
It's the same document. That
Reference
was
to
accepted for value,
the-
return for value yesterday. The same document.
It's not the same. The changes were put on the record verbally by the state. It's taking out reference to Sallyport of the Waukesha County Jail, referring to it simply as a garage attached to the Waukesha County Courthouse. I believe the rest is the same.
So it was a couple words changed.
That's my understanding.
So it's the same document.
Let me know when you're finished reviewing it and
I don't have to review the same document that was reviewed yesterday, accepted the value in return for value yesterday.
Right, then let me ask you this, sir. Do you have a position on the proposed instruction from the state.
It's essentially the same document. What was the significance of the change? What's the significance? Garage, Sallyport. What is the relevancy of what it's called?
State want to put on the record again the basis for the changes you made.
Your Honor, to my way of thinking, it is beneficial to the defendant. It removes any reference to a Sallyport, which some may recognize as being part of the Waukesha County Jail. It removes reference to the jail itself.
With that, sir, do you have any?
I don't fundamentally understand that. I think everyone's well aware that I'm in custody, so how does the wording change what's already known? Everybody knows that I'm housed in the Waukesha County Jail. How does the wording change what's already known? It's reported on every single day, as it has been since the beginning of trial and even before that. So I don't think anyone's not privy to the knowledge of where I'm housed and that I'm in custody. How does changing the wording change what's already known?
Thank you. This instruction will be read while we are still in the courtroom prior to the parties and the court going to the Sallyport for that viewing. And I've already discussed how it will be contemporaneously recorded so that it's part of the record as well.
So if I was there, where will I be at?
And my understanding is we'll have sort of assigned places and that it's only myself who will walk around. And I may not even do that. I have to think about that. But the jurors are the ones who are going to walk around the vehicle one time.
So I don't get to walk around the vehicle?
I can have you do that before the jurors come in. I certainly can have you do that if you would like. I can give the parties that opportunity.
I have a question to that.
Okay.
How come none of that knowledge of how it would be conducted was discussed with me? I didn't know anything about how the bailiffs would actually do things, how certain things would go. This is my first time hearing this.
Well, we have
I don't understand it.
We had preliminary discussions at the time of the request back in August when you still were represented by counsel. And then I had some additional preliminary discussions, if you will, internally with court staff, which included Captain Dussault and someone from the jail to talk about it and the logistics of it. And then, of course, we're having the discussion now. I did not have any discussions with the state myself. That only happened in the setting of a courtroom or when a letter was received and I reviewed it.
I haven't reviewed that letter or seen it. Don't you think that?
It was specifically addressed at the jury status hearing, at which time he was represented by Attorney Perry and Attorney Keys. It is on file and it was addressed by this court. Many of these details, Your Honor.
All right.
Many of the same details that's being discussed right now at this moment.
All right, Mr. Brooks, do you have a request as it relates to any of that?
Well, yeah, I'm still trying to understand the whole how this is all working, and then it was a reference to how the shackles would look, or how being shackled or not being shackled. I'm guessing that I can't just walk around freely with bailiffs. I'm sure there would be some type of shackles.
I will tell them you are not to be shackled visibly for the jury to see.
And what do you mean by visibly, Your Honor?
So, obviously when you sit in court, you're shackled to a table. They can't see that. I'm not going to have you in belly chains or in leg shackles. You're just going to be escorted. And it will be up to them how they determine
Well, he may be in leg shackles, Your Honor, if there's a table or some way that they can keep that out of the view of the jury, just like he is in court. He's shackled in court. He has been for 3 weeks.
Actually, these are,
The security has to be left at the discretion of the sheriff's department.
actually, these are leg shock devices, not shackles.
Sir, the security is up to the sheriff's department. I should be careful not to overstep my bounds on that. And, you know, whatever is done, it should not be viewable or visible to the jury.
And why is that, Your Honor? I don't understand that part. Why is the jury not privileged to see
That is to your benefit.
shackles?
I'm not going to explain that any further.
I don't understand. I'm just seeking to understand. I don't know.
All right, I need to move on. So unless there's a specific request, other than a statement that you're making about your lack of understanding, I need to move on with the other topics.
There is
I
a
need to
specific
cover.
request. Why do I have to have ankle shocks on my ankles to appear at this jury view thing?
I guess I'm not aware of what you're talking about. So were you advised by the sheriff's department that that would be the case?
Well, the DA just said that I would have the ankle shocks on.
No, shackles, she said.
No, these are not shackles. They're a shock device.
Judge, I think perhaps we can move on. I think maybe because this is going to have to occur on a break, the bailiffs can take him down there if Captain Dussault is willing, show him what it's going to be like, show him how he's going to get there, and he can decide at that point if he wants to be there or not when the jury comes in the room. We're spending a lot of time talking about security and things that are frankly beyond your knowledge and my knowledge.
I object to that. I'm simply trying to understand, why do I need ankle shocks?
I leave the security of the jury view to the Waukesha County Sheriff's Department. That is their responsibility. And I trust that they will do what needs to be done to maintain the security, no different than what they do here. And in their discretion will determine how best that takes place. And if I need to address anything after that or at that point in time, then it should be brought to my attention, but we are going to move on this morning.
So I should discuss that with the sheriff?
Yes. So I know, Mr. Brooks, you filed with the court 2 documents. I'm going to take them under advisement.
No,
I'm
it's
not
one
going
document. It's one. It was 2 papers, but it's one document.
Oh, all right. Thank you for that clarification. It's 1 filing, 2 papers, just front side, entitled Alleged Defendant Jurisdictional Challenge and Mandatory Judicial Notice by Affidavit. It references the case caption, the case number. I will simply take it under advisement and I'll review it later. And if I believe it needs to further be addressed, I will do that. But it's my understanding, sir, that you are requesting the original back. Is that true?
Yes.
So normally, just so you know, when documents are filed with the court, again, I've advised you of this previously, but in the courtroom, we don't have the time stamp. We just have the date stamp. I will state for the record that you provided this. It was right away at the beginning of the morning. So at 8:30 a.m. is when it was filed with the court. So that will be on the record. And then at some point today, when we're on a break, my clerk can scan it in and then provide the original back to you. And then I'll have the electronic copy to review and address as I deem appropriate. Here you go, Madam.
I want to say to that too, in reference to that, I actually said on record numerous times that I wanted the original copies of all my filings. I've actually said that 3 times on the record. This would be the 4th time. Every filing that
I'm going to give it back to you, sir, but I'm not required to by law.
Well, I'm just saying on record that I've asked for that numerous times.
Your statement's noted for the record. All right.
So would I be able to get all the original copies of all my filings?
I'm not going to address that any further, sir, because I am not the official keeper of the record. As to what was filed this morning, as a courtesy, we will provide you back with the original once it's scanned and it's in my electronic file.
I was told that you make the decision if I can get the original copy.
And I just made a determination you could have the original back of this.
Can I have the originals for all my filings?
I'm not going to address that right now, sir. I don't have time, frankly, to look through everything that you filed to determine whether we've given you originals or not. In the future,
I have the copies. I don't have the originals.
all right, I'm going to move on.
I have
sir.
them here.
This is taking up valuable time with the jury. We need to keep going.
Is that a judicial determination, Your Honor, that I can't get an answer to
I don't
something?
believe there's any other preliminary issues we need to address.
I'm still wondering, when I will get the copies back for the, ICFs that I filed.
I can't answer that, I don't have those, sir. You'll have to reach out to Clerk of Court Monica Paz.
Well, what happened to them?
I don't know, they're not part of the record, so you'll
They
have to
should
take
be.
that up with her and make communication form and ask her for those, but I'm not gonna address that any further on the record. All right, let's
should
bring the
be.
jury out.
It's kind of funny that they disappeared. No,
that
ICF
assumes
disappeared
fact, not
before.
evidence, sir, so.
They haven't disappeared before. I've always got copies. What's the difference now? So I have to readdress her the same thing in order to get copies that I've always been getting since the beginning of you telling me to file ICF.
I don't have them, they're not part of the file.
Then why were you getting them before?
You'll have to ask her that.
I have to ask her why you were getting them before?
My understanding is they were forwarded to me, sir, but well,
So what happened to this one being forwarded to you?
sir, I can't answer that. I can't answer what I don't know. So
It
the
seems
jury's
like you're
coming
trying to
in. We're
avoid
gonna
it. That's
we're
what
gonna
it seems
continue
like.
with the trial. So thank
Just like
you.
you avoided subject matter jurisdiction. You haven't proven that on the record.
Are you aware as to whether or not the school district maintains security cameras at the buildings on the school district property?
Yes, we do.
Overruled. It's foundational. The witness may answer.
I'm sorry.
Yes, we do.
Okay. And specifically, is there school district property located at the address of 222 Maple Street or Avenue in the city of Waukesha?
Yes.
Overruled. It's foundational.
Is there more than one security camera on that building?
Overruled. The witness may answer.
Yes.
How many are there, sir?
Overruled.
When the police came to you in the days following November 21 of 21, did they ask you to check a certain day and time on the video recording for the building at 222 Maple?
Objection.
Overruled. The witness may answer.
Had you changed or altered the content of the recording in any way?
Objection, leading.
Overruled. The witness may answer.
No, I have not.
Do you recognize what we're seeing there, sir?
Yes.
Could you please tell us what is shown on the front screen of Exhibit 157?
Objection, leading.
Overruled. The witness may answer.
This is the side of our Lindholm Administration Building at 222 Maple.
Okay. Do you believe the video contained in Exhibit 157 will be a true and accurate depiction of the events from this location on November 21 of 21?
Objection, speculative.
Do you want him to see the video first? Why don't you show him the video first?
Well, the video is 20 minutes long, Your Honor.
Oh, all right.
Or I'm sorry, 11 minutes long. Do you recognize what is shown in Exhibit 158?
Yes.
Please describe it.
Objection, leading.
Overruled. The witness may answer.
This is our rear parking lot at the Lindholm Administration Building.
At that same address?
222 Maple, yes, that's correct.
Is this a second camera?
Objection, leading.
Correct.
Overruled.
Entire video is 11 minutes in duration. Based on the testimony of the witness, I do not intend to play any of it at this time, but I would move to admit 158.
Objection. It's not intended to play. What's the relevancy?
The objection is noted. It's overruled.
Do you recall when you saw those videos?
I saw those Monday morning when my detectives came and asked me to review video footage.
And do you recall the name of the detective that you reviewed the footage with?
I do not recall the name of the detective, no.
And do you recall being informed that it was a possibility that you would be testifying in this matter?
No, I did not know that.
Were you subpoenaed at any time?
Yes, I was.
And do you recall who served you the subpoena?
Objection relevant.
Grounds.
Overruled, the witness may answer.
The district attorney's office from Waukesha.
Do you recall if it was a specific district attorney?
I do not recall.
Do you recall if you were contacted by the plaintiff in this matter?
Objection.
Grounds.
Vague.
Sustained as to the form of the question.
Do you recall having a conversation with the plaintiff?
Objection.
Grounds.
Misleading, legally inaccurate statement.
Grounds.
Sustained as to the form of the question.
Do you recall having a phone conversation with the plaintiff in this?
Same objection.
Grounds.
Sustained as to the form of the question.
Do you yourself recall reaching out to the plaintiff in this matter?
I'm not sure who the plaintiff is. Can you define that for me?
The plaintiff would be who's bringing the claim.
And I object. Well, I realize there's no question at this point, but if he's going to ask the witness to answer his prior question, now that he's clarified, this is irrelevant questioning.
We'll see what his question is first.
I asked it.
Please ask your question again, so that I'm clear.
Have you yourself ever reached out to the plaintiff in this matter?
And my objection is it's vague and it's legally inaccurate.
Sustained as to the form of the question.
Do you even know if there's a plaintiff in this matter?
Objection
Grounds.
argumentative.
Sustained as to the form of the question.
Have you yourself filed any complaint in this matter?
Objection irrelevant.
Overruled, the witness may answer, sorry.
I have not, no.
Do you know of anyone who filed a claim in this matter?
Objection
Grounds.
irrelevant.
Overruled, the witness may answer.
I do not.
Do you have any security cameras at your home, sir?
I do.
And do the security cameras have a way to record or save events that are captured on the camera?
They do.
Overruled, foundational.
To your knowledge, sir, was your security camera system operational on November 21 of 2021?
Objection
Yes.
speculative.
Overruled, the witness may answer, and he did his answer.
Was there a time where you turned over video from that security system to Waukesha Police sometime around November 21 of 2021?
Objection leading.
Overruled, the witness may answer.
Yes.
What kind of security camera do you have, sir?
Objection leading.
Overruled, you may answer, sir.
It's just a generic NVR system.
Before you turned it into the officers, did you alter the content of the video in any way, sir?
Objection speculative.
Overruled, please wait, sir. Overruled, the witness may answer.
Absolutely not.
I'm going to have Exhibit 155 displayed on the screen in front of you, sir. Do you believe that's a true and accurate capture of the events at your residence on November 21 of 21?
Objection speculative.
Overruled, you may answer.
It is.
I notice in the upper right-hand corner of the video, there appears to be a date and time stamp. Do you see that?
Objection relevancy. Any idea exactly what we were looking at?
Recorded footage of my backyard.
pretty standard to any other footage from any other day?
I guess I don't understand that question.
Is it pretty much the same thing you would see any day if you viewed that footage?
It's recorded footage in my backyard.
Is it pretty much the same footage you would have saw if you viewed it every day?
Sure.
And do you recall if you were subpoenaed to testify in this matter?
Yes. Yeah, I received a letter.
Do you recall by whom?
Waukesha County was on the envelope. I don't remember the names on it.
Did you yourself at any time file a claim in this matter?
No.
Do you know of anyone who has filed a claim in this matter?
No.
Have you ever talked to the plaintiff in this matter?
Objection.
Grounds.
Vague.
Sustained as to the form of the question.
Have you yourself ever reached out to the plaintiff in this matter?
Objection.
Grounds.
Vague.
Sustained as to the form of the question.
Have you ever had any personal interaction with the plaintiff in this matter?
Objection.
Grounds.
Vague, argumentative, irrelevant.
Sustained.
Sustained for those reasons stated by.
Sustained as to the form of the question as well.
Are you sure if there's a plaintiff in this matter?
Objection.
Grounds.
Argumentative, irrelevant.
Sustained for those reasons.
Were you at any time informed that there's a plaintiff in this matter?
Objection.
Grounds.
Irrelevant.
Sustained.
For the reasons stated by the.
Sustained.
For the reasons stated by the secretary.
Also as to the form of the question.
Have you at any time seen anywhere or read anywhere that there's a plaintiff in this matter?
Objection, Your
Grounds.
Honor. Irrelevant.
Grounds.
Sustained. Also as to the form of the question.
Sir, on November 21 of 2021, where did you live?
435 Dunbar?
Is that here in the city of Waukesha?
Yes.
And is that your home?
Yes.
Overruled is foundational.
Do you have any security cameras at your home, sir?
Yes, I do.
And did you back then in November of 21?
Objection leading.
Overruled, the witness may answer is foundational.
Yes.
To your knowledge, were they in working order on November 21 of 21?
Objection speculation.
Overruled, the witness may answer.
Yes.
Does your security camera have recording capability?
Objection leading.
Overruled, the witness may answer.
Yes.
Close to November 21 of 2021, maybe a day or two later, were you contacted by the Waukesha Police Department?
Objection leading.
Overruled.
I was contacted on Monday and on Wednesday.
Did they specifically obtain recordings related to the date of November 21 of 21?
Objection leading.
Overruled, the witness may answer. It's foundational.
Yes.
Did you change the content of the recording in any way?
Objection leading.
Sorry.
And speculative.
Overruled as to both objections, the witness may answer.
Nothing was changed.
This is a 9-second clip. Can you see that, sir?
I can.
And if you look on the screen, sir, do you see a date and time stamp for the video?
Yes.
Objection leading.
Overruled, the witness may answer.
What was the date and time stamp that the video was recorded, please?
November 21, 2021 at 4:46:41 p.m.
Would you say it's fair to say that from the video, this is a pretty good distance from where your camera was positioned?
That video image is a good distance. It's about 50 yards.
And you can tell from the video that you just watched today, you can tell the
gender of the individual that you saw crossing the street, as you say?
Well, when I saw it originally, I had zoom. Okay, the feature of the camera zooms. So your image was real clear.
So the image was real clear when you had zoom. Any reason why this particular image doesn't have that feature?
They can do whatever they want.
Brown.
Objection.
Hold on, there's an objection. Let me rule on it.
Beyond the scope of the witness's knowledge, Your Honor.
I'll overrule if you know the answer.
I don't know what decisions they made in choosing the display.
And do you recall when you were subpoenaed to testify in this matter?
Late July, early August.
Do you recall by whom?
Waukesha County District Attorney's Office.
Do you recall whose name was on that subpoena?
I would have to take a look at it to recall it.
Did you yourself at any time file any claims in relation to this matter?
No.
Do you know of anyone who filed any claims in relation to this matter?
That's a privacy issue.
You may answer the question.
I know that my grandchildren received counseling, and I think that a Waukesha Community Fund might have helped cover some of that.
Do you recall the name of the fund?
No.
And to your knowledge, the fund that you speak of was strictly geared towards counseling?
I'm not privy to what it was geared toward.
So would it be fair to say that there was a financial interest attached to this incident?
Absolutely not.
And
There's a mental health interest.
And how's everybody doing now? Are they okay?
Objection, irrelevant.
Grounds
Sustained.
for relevance?
Yes.
Have at any time you yourself had any personal interactions with the plaintiff in this matter?
Objection.
Grounds.
Sustained is to the form of the question.
Do you know if there's a plaintiff in this matter?
Objection.
Grounds.
Relevant.
Sustained.
Grounds for the sustain, Your Honor.
Not relevant.
Do you recall if the plaintiff in this matter reached out to you in any way?
Objection.
Grounds.
Irrelevant, asked and answered.
Grounds.
Sustained for those reasons. Also as to the form of the question.
Just for the record, it wasn't asked and answered, just for the record.
Next question, please.
Do you yourself know if there even is a plaintiff in this matter?
Objection, argumentative.
Sustained. As to the form of the question.
Mr. Miller, on November 21 of 2021, where did you reside?
Overruled, the witness may answer.
126 Central Avenue,
And that's here in the city of Waukesha?
Waukesha, yes.
Okay. Do you have any home security systems in place at your residence, sir?
Objection speculative.
Overruled, the witness may answer.
Yes, I have 2 doorbell cameras. I noticed somebody running up my driveway on the one camera.
Did you
So
recognize the person?
I did not.
Okay.
Sorry.
Hold on, there's been an objection. It's overruled. His answer may stand.
So you saw somebody on the recording that you did not recognize.
Correct.
What?
Hold on. Overruled.
Asked and answered.
It's foundational. I'll allow it, but please move on.
It's asked and answered already.
What?
Go ahead.
I believe it was a detective called me and asked if I could send them the copy of the video.
Did you do that?
I did.
Prior to doing that, did you alter the content of the video in any fashion, sir?
No,
Overruled.
Mr. Miller, is that the recording you provided to the Waukesha Police Department?
yes,
Do you believe this is a true and accurate depiction of the events at your home on November 21 of 2021?
Objection, relevancy.
Overruled. You may answer.
yes,
In the upper right-hand corner of the recording, I noticed there's a date and time stamp. Do you see that?
yes,
Objection, leading.
Do you believe that was accurate
overruled.
reflection? I'm sorry.
There's, the witness's answer may stand.
When you received the subpoena, did you follow up with the district attorney's office? I'm assuming that that's who served the subpoena.
I did.
Do you recall whom you spoke with?
I do not recall the name. Sorry.
Did you yourself file any claims in relation to this matter?
I have not.
Do you know of anyone who filed a claim in relation to this matter?
Personally, no.
To the best of your recollection, do you recall being contacted by the plaintiff in this matter?
And other than regards to the summons, no.
And you made reference to the summons.
Or subpoena, rather.
What was the plaintiff's name on the subpoena?
I believe so.
Do you recall what that name was?
The state of Wisconsin.
Have you ever had any interactions with the state of Wisconsin?
Objection.
Grounds.
Relevant, vague, argumentative.
Grounds.
Sustained.
For those reasons, Your Honor, or?
Sustained. Yes.
Being that you identified the state of Wisconsin as the plaintiff, have they ever reached out to you in any way?
Objection.
Grounds.
Sustained is to the form of the question.
Have you ever had any personal interaction with the state of Wisconsin?
Objection. Vague,
Grounds.
irrelevant, argumentative.
Grounds.
Sustained.
For those reasons stated by?
Yes.
Would you yourself classify the plaintiff that you identified, state of Wisconsin, would you classify them as a living human being?
Objection.
Grounds.
Vague, irrelevant, argumentative.
Sustained for those reasons.
Would it be fair to say that a state cannot be a human being?
It could be argued philosophically, I guess, yes,
And
but I don't know. No,
no?
personally, no, but philosophically, I suppose you could argue that the state is a person.
The state, one state?
I suppose it could be argued.
And with determination, how did you come to that determination?
Objection. He said he did. Your Honor, that's a misstatement of his testimony.
Sustained is to the form of the question, it's also not relevant.
Do you see the state of Wisconsin present in the courtroom today?
Objection.
Grounds.
Irrelevant.
Sustained, not relevant,
What was the last part, Your Honor?
not relevant.
Have you ever seen the state of Wisconsin at any time?
Objection.
Grounds.
Argumentative.
Grounds.
Irrelevant.
Sustained for those reasons.
What reasons are there here?
For those reasons, it was also asked previously and I sustained the objection.
That question wasn't asked previously, for the record. So to the best of your knowledge, is the state of Wisconsin an injured party in this matter?
Your Honor, I object. And
Grounds.
ask you to direct the defendant to move on.
Grounds.
The
I think
objection
the
is
judge has to do that, not the
pursuant,
DA.
the objection is sustained. Next question, please.
I'm sorry, I didn't hear the reason for the sustain.
It's not relevant.
Your Honor, I object to it not being relevant. It's clearly stated
Mr.
the
Brooks,
plaintiff.
please move on. I've made my ruling. Thank you.
I don't know how that's not relevant. It seems to me that there's no plaintiff.
I remind the jury to disregard comments made by the parties. They are not evidence.
There's no plaintiff. Your Honor, for the record, subject matter jurisdiction, as you proven for the record.
Your objection to that is noted. I'm declining to revisit that issue, sir.
Is that a judicial determination?
It is.
Directing your attention to the date of November 23, 2021. Were you on duty that day?
Yes, I was.
What duties were you tasked with on that day?
Me and several other officers, detectives were tasked with being part of the search team canvassing the area for items.
Okay, and this is related to the investigation into the Christmas parade?
Objection, leading.
Okay.
The objection's noted. It's overruled.
So you said the purpose of the team was to look for items, did you say?
Objection, leading.
Overruled.
Yes, items that we believe Mr. Darrell Brooks was wearing the night of the incident.
What day was this that you set out to do this?
November 23rd, 2021.
Was there an objection or not?
Yes.
Overruled. The witness may answer.
It was November 23rd, 2021.
Did you personally recover any items of interest in this case, sir?
Yes, I did.
Can you tell us about that?
Yeah, the first item that we located was a blue sandal, or they also call it a slide, that was located at 322 Maple Avenue in the backyard.
Is that on your screen, sir?
Yes, it is.
Do you identify, or excuse me, do you recognize what is depicted in Exhibit 94?
Objection, leading.
Overruled. You may answer.
Yes, I do.
Tell the jury what you see in 94.
It is the blue sandal that was outside the fenced, chain link fence area like I described. It is a navy blue in color, and it also had a Milwaukee Brewers logo album on the front of the sandal, which appeared to be like torn or worn.
Do you believe Exhibit 94 is a true and accurate depiction of the area where the sandal was found?
Yes, I do.
And the exact location where the sandal was found?
Objection, leading.
But it's shown in 95.
The navy blue sandal that I just described.
Similar, or how is 95 different from 94?
Objection, leading.
Overruled. You may answer.
They were the same exact sandal, just different pictures.
That's what I mean. What's the difference between the photographs?
Objection, leading.
Overruled. The witness may answer.
Just the angle of where the picture was taken.
You had described in your testimony a chain link fence, correct?
Correct.
Does that separate two properties?
Objection, leading.
Overruled. The witness may answer.
Yes, it does separate two properties.
And what are those properties, please?
Objection, relevancy.
Overruled.
You set out to search the area around 338 Maple, correct?
Yes, that is correct.
And what was the significance of that address, please?
That was where the vehicle was located that Darrell Brooks was driving the night of their Christmas parade.
Okay. And could you please approximate for us the distance between the residence where the vehicle was found and the residence where this sandal was found?
Objection, relevancy.
Overruled. The witness may answer.
This is an approximate guess. I guess around 200 yards.
Can you please circle the sandal in the photograph? All right, thank you. All right, now 95 is up, sir?
Same thing, circle?
Sure.
Objection, leading.
Yes, please circle.
Overruled. The witness may answer by circling.
All right. I'd like to show you a piece of physical evidence that's been marked as State's Exhibit 86. If I could get the assistance of the deputy, please. you please present that to the witness for me?
Is that, it said 86?
I was gonna ask the same thing because I missed that too. Can I have the number again?
Yes, 86, Your Honor.
All right, thank you. Exhibit 86. Not yet.
Sir, have you seen Exhibit 86 before?
Yes.
What is 86?
86 is the sandal that I located outside of 322 Maple Avenue.
One we are just seeing in the photographs 94 and 95?
Yes.
Okay. Move to admit 86, Your Honor.
Objection, relevancy.
Overruled. Exhibit 86 is received.
Officer Becker, did you find any other items of significance to this investigation?
Objection, leading.
Overruled. The witness may answer.
Yes, I did.
Where did you find these items?
I located a children's playhouse. This children's playhouse was made of wood, and it had about 4 or 5 steps up till we got to the platform of the children's playhouse. There also was a slide connected to it that would lead down to the grass. I located in that platform area, I located the gray hooded sweatshirt that had a multicolored design. It's the same sweatshirt that we believe Mr. Brooks was wearing during that parade.
All right, Officer Becker, could you please circle for the jury the children's playhouse that you've been describing for us? And where's the, this is a close-up of that same playhouse?
Yes.
Do you see the sweatshirt in this image, sir?
Objection, leading.
Overruled. You may answer.
Yes, I do.
Please circle it. And those are the 2 items together in the top portion of the playhouse, is that right?
Yes, it is.
All right. Number 84. Do you recognize item number 84, sir?
Yes.
What is that?
Objection, leading.
Overruled. I'm sorry. What was the number again?
84.
All right. Go ahead. You may answer, sir.
Yes, this was the gray hooded sweatshirt that I located in the children's playhouse.
All right. And 85. Thank you. Please identify.
This is the other sandal, which was a left-footed blue sandal slide with the Milwaukee Brewers logo that was also located in the children's playhouse.
Objection, relevancy.
Overruled. Exhibits 84 and 85 are both received.
And I'd like to ask, with the court's permission, if 84 can be published by the officer standing up and holding up 84 for the jury to view.
Objection, relevancy.
Permission granted.
So please hold up the sweatshirt, sir.
Objection noted.
Yes. The record to reflect the officer stood up in the jury box. He is holding the exhibit between his waist and forehead. That's the full length of a sweatshirt, and he has passed it from right to left of his body in front of the jury.
Thank you. And then if you would do the same thing, please, sir, you could set that one down, and if you could hold up 84 and 85, one in each hand, and display those for the jury, if that's okay, Your Honor?
Go ahead.
I'm sorry, 85 and 86.
Objection.
Your objection's noted. Go ahead. The witness is standing up still in the witness box. He is holding each one of those exhibits, which I believe is 85 and 86, one in each hand at shoulder height, and he turned a bit from right to left in front of the jury.
You testified earlier in questioning, or rather, let me back up. You said the name of the alleged suspect when questioned about the alleged suspect fleeing from the vehicle. At that time, did you know the name of the alleged suspect?
Yes, we did.
And how did you obtain that information?
From detectives working the case.
So you yourself didn't know until you were told. Would that be fair to say?
I was part of the brief, so I knew too.
So you knew before you were briefed?
Yes.
So you knew before you were briefed, then why did you have to be briefed about that information?
Just the gatherings, we briefed every morning, and the gatherings from the day before what we were all going to do.
And in reference to the sweatshirt that you observed in the children's playpen, do you have any information of how that got there?
Not exactly, no, because I didn't follow the footsteps of Darrell Brooks at night.
You testified earlier, and I don't want to misquote you. I think it was some question of determining the distance. I don't know if that was in reference to where the vehicle was found and where the items that you found were located. Was that the distance that was being referred to?
Yes, I believe so.
Thanks for that clarification. I didn't want to misquote you. How were you exactly able to determine the exact distance of that?
I wasn't able to. I think I may have stated it's a rough estimate or approximate.
So it'd be fair to say you don't know for sure the distance?
No, I do not know for sure the exact distance.
Would it be fair to say that these items have been kept for quite a while now? Would that be fair to say?
Yes.
Are items usually kept for this length of time in investigations?
Yes, typically yes, till the case is over.
So it isn't unusual in any way to see items kept roughly a year or so?
No, that's not unusual, especially if it's evidence to a crime.
To the best of your knowledge, did you yourself file any claims in this matter?
No, I did not.
You know of anyone who filed any claims in this matter?
No.
Have you at any time saw or read a complaint in this matter?
No.
And do you recall who you were subpoenaed by to testify in this matter?
Yes, state of Wisconsin.
And who do you refer to when you say state of Wisconsin?
District Attorney's Office, Waukesha County District Attorney's Office.
Do you recall whose name was on the subpoena?
I do not recall. I'd have to look at the paperwork.
So to the best of your knowledge, would the state of Wisconsin be the plaintiff in this matter?
Yes.
And do you see the state of Wisconsin plaintiff in court today?
Objection.
Grounds.
Proper day question. Sustain us to the form of the question.
Is the plaintiff present in court today, to your knowledge?
Objection.
Grounds.
Relevant, legally inaccurate statement, Your Honor. Sustained.
Do you recall having any personal interactions with the plaintiff in this matter?
Objection.
Grounds.
Sustained to the form of the question.
Have you ever been contacted by the plaintiff in this matter?
Same objection.
Grounds.
Sustained to the form of the question.
If you were to see the plaintiff, state of Wisconsin, will you be able to identify him?
Objection argumentative.
Sustained to the form of the question.
Would you classify the plaintiff, state of Wisconsin, as a human being or an entity?
Objection irrelevant.
Sustained.
Would it be fair to say this isn't your first time during your career testifying in any type of criminal matter?
Yes.
Yes, as in,
I've testified before.
so it would be fair to assume that you understand plaintiffs and defendants, correct?
Objection, irrelevant.
Sustained, not relevant.
Are you aware that only a living human being can bring a claim against a defendant?
Objection, irrelevant, argumentative.
Grounds.
Sustained for those reasons. And as to the form of the question.
To the best of your knowledge, who can bring a claim against an alleged defendant?
Objection, irrelevant.
Sustained, not relevant. Ladies and gentlemen of the jury, you will now be taken to a garage attached to the Waukesha County Courthouse to view the vehicle recovered by the Waukesha Police Department. You will be taken to the garage by the jury. During your trip to and from the garage, you are not there to discuss this case with anyone. While at the garage, you are not, and no one is to talk to you about the case except the judge. You are to remain with the other jurors. You are not to conduct an independent investigation now or at any time during the trial. The court is taking the jury to the garage to provide the jury with an opportunity to view the vehicle, as it is not possible to bring the vehicle into the courtroom. Other than the vehicle, anything you see there is not evidence in the case and should not be considered as evidence. We all were positioned in various locations within the garage. The belly chains and handcuffs were removed from Mr. Brooks. He did not have leg restraints on that I could see. And so when the jury was brought in, he was not in any of that. And then I instructed the jurors at that point, our civilian bailiff, Michael, was in the lead. I said, please come in, walk around the vehicle one time slowly with the jurors.
Subject matter jurisdiction, Your Honor.
The court's declining to address that further. I stand by my written decision that was entered last week.
So we won't be proving it for the record?
I stand by my written decision that was entered last week, sir.
Judicial determination?
It is a judicial determination.
Were you present when any items were discovered that were relevant?
Yes, I was.
And just very briefly describe what those items were, sir.
Objection, leading.
Overruled the witness may answer.
A blue sandal up against a fence area that separates the Dunbar neighborhood or street homes from the Maple Avenue apartment complex. From that sandal, some other investigators did locate a sweatshirt and a left-footed blue sandal.
Now, in addition to looking for items, did you and other detectives attempt to obtain video from homeowners and businesses in the area?
Objection, leading.
Overruled is foundational. The witness may answer.
Yes, we did.
And do you recall obtaining a video from the school district?
Yes, we did.
And do you recall what building or buildings from the school district video was recovered from?
Objection, leading.
Overruled.
Did you also obtain video from homeowners on Dunbar?
Objection, leading.
Overruled. The witness may answer.
Yes, we did.
Specifically 435 Dunbar?
Correct.
Objection, leading.
Overruled is foundational.
Objection. Connected to the video.
Your objection is noted. It is overruled. Exhibit 131 in its entirety is received. And did you ask for permission to publish?
I did.
Go ahead.
I'm going to ask that we play this clip, Your Honor, and for the record, it's a total of 20.81 seconds.
Go ahead.
Objection.
Your objection's noted. Go ahead and play.
What do we see in slide number 6?
A
Upper left-hand corner is a still shot of the video, and below that is a screen capture of a figure in that photo.
Okay. With sound on this one, yes, thank you.
Excuse me.
What do we see on this final slide, sir?
Upper left-hand corner is a still shot from the video, and the screen that's been cropped at the bottom is a image of the defendant.
Detective Rowe, based on these video clips that you obtained and the canvas that you and your team did in the neighborhood, were you able to put together a map basically tracking the travels of Darrell Brooks through the neighborhood that afternoon?
Objection, I don't consent to being called that name. Leading.
The objections are noted, overruled. The witness may answer.
Yes.
And I should include, do you know the location where Darrell Brooks was arrested?
Objection, I don't consent to being called that name.
Overruled. The witness may answer.
Yes, I'm aware he was arrested on Elizabeth Street.
Okay. And are you aware of reports to other officers as far as citizens that had contact with Mr. Brooks in the area of Elizabeth Street?
Objection, I don't consent to being called that name.
Noted. The witness may answer.
Yes, I'm aware.
All right. Behind you, sir, is a large poster board that's facing backwards. I'm going to ask you to please assist me by putting that face forward on the easel behind you. And we're also going to put up the digital copy, Your Honor. I just wanted to.
Oh, okay. Then that's fine then.
Okay.
Thank you.
I'll have him work off the digital copy, but before you sit down, Detective Rowe,
Sure.
in the bottom right-hand corner of that poster board, there is a sticker. Do you see that?
Yes, sir.
Objection, leading.
Thank you.
Detective Rowe, do you believe that Exhibit 130 is an accurate summary of the travels and the contacts by Mr. Brooks on the evening of November 21, 2021?
Objection, I don't consent to being called that name.
Overruled. The witness may answer.
Yes.
Move to admit 130 and permission to publish, Your Honor.
Objection.
I'm sorry. I cut you off. What's the basis, if you have?
Relevancy.
All right. The objection is noted. It is overruled.
The northernmost event that's reflected on the map reads what?
Officer Skolton shoots that SUV at 4:39 p.m.
Okay, do you know that to be accurate based on your knowledge of this investigation?
Objection, leading.
And then there appears to be a red line from that point going south down the middle or right side of the map. Do you see where I'm referring to, sir?
Objection,
Yes, sir.
leading.
And where did it go? What roads?
Objection, leading.
I'm going to ask Ms. Gussie to please zoom in on that upper right-hand quadrant of the exhibit, please. And specifically the area of 338 Maple, please. Okay. So you said the vehicle traveled through the backyards off of Prospect Court, is that right?
Objection, accident, yes, sir.
Can you point out the path of the vehicle that you just were describing for us?
Objection, leading.
When it turns off of Prospect Court, is that a road?
Objection, leading.
I'm sorry, when it left Prospect, I'm sorry.
Sir, which question were you objecting to?
The last one.
About which way it turned? Or turning onto Prospect?
The way it was actually.
So the line you drew from south from Prospect Court represents what, sir?
Objection, leading.
Do you see a blue dot in the same area we're talking about here?
Objection, leading.
What's the address of Les Paul School,
Objection.
if you know, or the street?
Relevancy.
I notice the line becomes dashed. Do you see that?
Yes.
Objection, leading.
Do you see then, moving back to the left on the map, the two boxes in white depicting where the sandals were recovered?
Objection, leading.
So there's two green X's, correct? You see where I'm referring to, sir?
Objection leading.
Did we just see the video of him crossing the street there on Dunbar?
Objection leading.
Did we just see the two videos from those two cameras at the Wyndham building in the last exhibit, 131?
Objection leading.
Is that the location of Central Avenue, sir? I'm sorry, 417 Central Avenue?
Objection leading.
Can you please circle these two conversations that you just identified for us?
Objection leading.
What's happening in this area, please?
Objection speculative.
Was that in exhibit 131 that we just showed the jury?
Objection leading.
Which video was that one, do you remember?
Objection leading.
Now, at this point, the dash line ends. Is that right?
That's correct.
Why is that?
Objection speculative.
Are you aware that there was a reported contact between Mr. Brooks and a witness identified as Aaron Cordes?
Objection leading.
Could you identify Aries Industries? Are you aware of video from that location showing person appearing to be Mr. Brooks approaching the front door lobby of the business?
Objection, I don't consent to being called that name.
Noted, the witness may answer.
Speculative.
Overruled, the witness may answer.
Yes.
Okay. Do you believe this map is an accurate documentation of the investigation, again, as to the travel of Darrell Brooks this evening, on the evening of November 21?
Objection speculative, and I don't consent to being called that name.
Your objections are noted. Overruled, the witness may answer.
I'm sorry, can you repeat the question?
Sure. Do you believe this map is an accurate summary of the travel and whereabouts of Darrell Brooks at various points on the evening of November 21?
Objection speculative, and I don't consent to being called that name.
Your objections are noted. They are overruled, the witness may answer.
Yes.
All right, thank you, Detective. I don't have any other questions.
Any cross-exam for this witness, sir?
Yep.
All right, thank you. Begin when you're ready.
So, Officer Rowe, you repeatedly referred to the alleged defendant's name. How did you come into that information?
Based on the entirety of the investigation,
And when did you come into the knowledge of the alleged defendant's name?
I don't remember.
When did your part of the investigation start?
After he drove the SUV through the parade, I was called at home to come in and help the departments with the investigation.
And just so we clear for the record, is the jury asking you questions or me?
I'm sorry, I did not hear the question. Repeat your question. Please.
Well, I was referring to when I ask a question, he turns towards the jury as if they're the ones asking the question.
That's not a question, Your Honor.
It is a question.
We did ask a question about that.
Yes.
I think you're asking why does he do that? To that extent, the witness may answer.
I'm here to present the case to the jury.
I follow that fundamentally. But for the sake of making sure you hear the questions right, wouldn't it be fair to say that you should pay attention to the questions being answered? Or being asked, rather?
Assumes the fact, not an evidence.
Sustained as to the form of the question. Please rephrase.
Wouldn't it make sense to focus on the questions so you can hear them clearly?
Objection argumentative still assumes the fact, not an evidence.
Sustained.
You made reference to you being here to present the case to the jury. So is that the reason why you decided to testify?
Objection to the relevance?
Grounds?
Overruled, the witness may answer.
I don't understand your question.
Were you able to hear my question clearly?
I don't understand your question.
Were you able to hear my question clearly?
Objection argumentative, Your Honor.
Sustained. Next question, please. Or rephrase the previous question to the one that was asked just now.
What was not understood about the question that you were asked?
Objection argumentative.
Grounds.
Sustained. As to the form of the question, please rephrase.
What wasn't clear about what I was asking?
Same objection, Your Honor.
Grounds.
The objection is sustained. Let's go back and ask the question that he says he didn't understand and rephrase it, please, or move on. Your choice.
Was your sole reason for testifying here today?
Objection relevance.
Let's let Mr. Brooks get the question out. Go ahead.
Apologize, I thought that was it.
Are you testifying today strictly to prove your case to the jury?
Objection, misstatement of his testimony.
Grounds. That's what he said.
Sustained as to the form of the question, misstates the prior testimony.
That's what he said. So why did you decide to testify here today?
Objection, that's a legally inaccurate question, Your Honor.
Please rephrase the question. I'm sustaining the question asked as to the form of the question.
I don't know how I'm supposed to rephrase that. Without having the same form of the question. That helps.
I'll rule if there's an objection, but ask a question, please.
Did you seek to testify here today in this matter?
No.
So how did you ultimately come to that decision?
Objection, that's a misstatement, Your Honor. It was not his decision.
Sustained as to the form of the question assumes a fact, not an evidence.
Were you subpoenaed?
Yes.
Do you recall by whom you were subpoenaed to testify?
District Attorney Sue Hopper from the Washington County District Attorney's Office.
And at that time you were subpoenaed, you decided to testify.
I don't believe it's my decision.
Well, it would be fair to say that you didn't have to show up, right? That'd be fair to say?
No, I had to show up.
But would it be fair to say that you could have chosen not to?
No, it would not be fair to say that.
Exhibit 131 that was shown to you, have you seen that video footage before today?
Yes, I have.
Do you recall who showed it to you before today?
I don't recall who showed it to me.
Would it be fair to say you've seen it multiple times before today?
Yes, I've seen it a number of times.
And do you recall when you were first shown that video?
Off the top of my head.
Was it the same day of the incident, the days following, sometime after?
I don't recall when I saw the video the first time.
And what about Exhibit 130? Had you seen that video footage before today?
Objection, Your Honor, 130 is the map.
Or the map? Have you seen the map before today? I don't really think it.
Just for the record, I'll sustain the objection just because it referenced the wrong number, but I believe you rephrased. So go ahead, the witness may answer.
Can I ask the question again, please?
Had you seen the map of Exhibit 130 before today?
Yes, I have.
Multiple times as well?
Yes, numerous times.
Any idea why you viewed it so many times, multiple times?
Unsure.
Were you able to obtain any more information upon seeing the map numerous times that you didn't obtain when first seeing the map?
No.
So it would be fair to say you pretty much knew what the map was detailing each and every time you saw it.
Yes.
And on that map, Exhibit 130, you made reference to at some point the dotted line, and it stops at some point. That'd be fair to say?
Could you be more specific?
The dotted line that was referred to on the map.
Do you want the map brought up? Would that be helpful to you?
Or maybe might be helpful to him.
He's got the large map, but if you want to.
So, if you can see the dotted line on the map behind you,
Yes.
is it fair to say that the dotted line stops at some point? Around Central Avenue, maybe?
Yes, there's a couple lines that seem to come to Central Avenue or egress out of Central Avenue that do stop.
And you stated that, well, what was the reason that you stated that that line stops, the dotted line?
It stated that it's because we don't know the exact location where you cross the street to get over to Elizabeth Street.
And why, were there no cameras present at that point, or how did you lose the path of travel at that point?
We didn't find any cameras or any eyewitnesses in that area.
So it would be fair to say at that point you weren't sure what happened.
I know that you crossed the street at some point. We just don't know where.
How do you know that?
Because you were arrested on Elizabeth Street.
Did you see any crossing of, I think you said that was West? Would that be West Avenue that you were referring to, that you don't see any crossing of?
What's your question?
Is that West Avenue that you stated that you didn't see any crossing of?
That is Northwest Avenue.
Or Northwest Avenue, I'm sorry, I don't know the streets. Northwest Avenue. And you don't have any visual footage or any eyewitnesses, as you said, to say for sure if Northwest Avenue was crossed.
We didn't obtain any witness statements or any eyewitness or any video of the suspect crossing the street.
What day were you doing your part of the investigation? Was that the same evening or the next few days after the incident, or?
Can you clarify which investigation you're talking about?
The one that you took part in. Your part of the investigation.
I don't understand what time frame you're asking for.
What day did you start your part of the investigation?
Well, we started the investigation as soon as he ran people over in the parade.
And you were there?
I responded to the parade after he had done that.
Were you at the parade?
No, I was not.
So it'd be fair to say you were on call?
No, I was not.
So it'd be fair to say you don't know when your part of the investigation started then, right?
Would not be fair to say that.
You don't recall what time it was when you started your part of the investigation?
As soon as I responded.
And you don't recall when you were dispatched to respond?
It's in my report. I don't remember the time exactly, but it's in my report.
And were you dispatched to any location from that point?
I was not dispatched.
Were you sent to any location from that point?
I was assigned with taking a number of investigators with myself and walking the entire parade route, going from establishment to establishment, bar to bar, restaurant to restaurant, and obtaining phone numbers and names of people who were present at the parade and who had witnessed something and would be followed up with later by a member of the Detective Bureau.
So it'd be fair to say you did some interviews at that time?
Yes.
Do you recall how many?
No.
And after conducting these interviews, what did you do?
I went home.
So at that time, after conducting your interviews and then going back to your home, did you have the name or ID of any suspects at that time?
Yes.
And whom were you told by?
I don't recall.
Do you recall who you submitted your typed report to?
I don't understand your question.
Do you recall who you submitted your typed police report to?
No.
I'm assuming your law enforcement agency doesn't type up reports and just leave them sitting on the desk. Would that be fair to say?
That'd be correct.
Any reason why you wouldn't recall who you gave your report to?
Well, it's electronically submitted.
And from there, does it have a specific sergeant or lieutenant or captain or someone that it goes to from that point? If you recall, or if you know?
I wouldn't know.
So it'd be fair to say, once you type a report and submit it, you're not sure who sees it.
Correct.
Would you say it's fair that because of you not knowing who your report is submitted to, that your report can be altered in some kind of way? Especially being that you don't know who sees it?
The reports are done via PDF style reporting. It's protected by my username and my password. And when it's submitted, it's usually not altered unless I request it to be altered.
But it is fair to say that there's a possibility that it could be tampered with because you don't know for sure who all sees it.
It's entirely inaccurate.
How so?
My report is accurate. My report is the way that it was written, the way that I wrote it myself.
So you've had a chance to read your submitted report after you submitted it?
Yes.
And to the best of your knowledge, is exactly word for word as you remember typing it?
It is my report. It is what I typed, and it is accurate.
Word for word?
Yes.
Do you recall how many pages long the report was?
Objection, relevance.
Grounds.
Sustained. Not relevant.
Do you recall if the report was lengthy?
Objection, relevance.
Grounds.
Sustained. Next question, please.
Grounds for the sustain.
Relevance.
And you stated that you read the report after you submitted it. Do you know how long it was before you were able to see the report that you typed?
Objection, relevance.
Grounds.
Sustained.
Well, he already answered that.
Then I'll object as asked and answered, Your Honor.
Sustained.
That question wasn't answered, but okay. I see. Do you recall when you typed your report?
Objection, relevance.
Grounds.
Sustained. Not relevant.
How's that not relevant if he already answered that he typed the report?
Please continue, sir.
Grounds for the sustain.
Relevance.
He answered that he typed the report. So how's it not relevant if he recalls when he typed it?
Please continue, sir.
You got to be kidding me. Did you file any claim related to this matter?
No.
Do you know if anyone who did?
Did what?
Do you know of anyone who filed a claim in relation to this incident?
No.
Do you know who the plaintiff is in this incident?
Objection,
Grounds.
relevance.
You may answer that question. Go ahead.
Can you ask the question again?
Do you know who the plaintiff is in this incident?
So, plaintiff would be the state of Wisconsin.
Is the state of Wisconsin a human being or entity?
Objection,
Grounds.
argumentative.
Sustained. On relevance grounds.
Have you ever had any interaction with the plaintiff in this incident?
Objection.
Grounds.
Relevant, legally inaccurate.
Grounds.
Sustained as to the form of the question.
Were you ever contacted by the plaintiff in this incident?
Same objection.
Grounds.
Sustained as to the form of the question.
Would you call the state of Wisconsin a living, breathing human being? Or
Asked and
entity?
answered.
Grounds, because I didn't ask that question.
It's not relevant. Sustained. Next
It's
question.
very relevant. Seems like there's no plaintiff.
Jury will disregard statements made by the attorneys and the parties. They are not evidence. Please
I'm
ask
trying to
the
be
question.
So to your knowledge, the plaintiff is the state of Wisconsin. Do you see him present in the courtroom today?
Objection, irrelevant.
Sustained.
Can you
Relevant.
identify the plaintiff state of Wisconsin?
Same objection.
Grounds.
Sustained. Sir, please continue and not on this topic. Next question, please.
To the best of your knowledge, you're not even sure if you've ever even had any interaction with the plaintiff state of Wisconsin, correct?
Objection, argumentative and compound.
Grounds.
Sustained.
Definitely wasn't compound. Would you consider yourself an injured party in this incident?
Objection,
Grounds.
argumentative.
The witness may answer.
No.
Have you read or seen the complaint?
No.
No further questions.
All right, thank you, sir. May I redirect?
No, thank you.
All right, thank you, sir. You may step down.
Detective Rowe should be dismissed, please. And yes, could we get the exhibit?
Yeah, why don't you grab that exhibit and take it?
My current position is the mechanical inspector for the Wisconsin State Patrol Technical Reconstruction Unit.
Can you describe the duties of that position?
Objection, relevancy.
Overruled, the witness may answer.
My job basically is to conduct thorough and systematic inspections of vehicles that have been involved in crashes.
Did you receive any training in order to perform those duties?
Objection, relevancy.
Overruled, the witness may answer.
Yes.
Can you briefly describe that training for the jury?
Objection, relevancy.
Overruled, the witness may answer.
Prior to this, I was a diesel mechanic, and in addition to that, I have ASE and SAE certifications.
And not having any interest in cars, what are those certifications?
Objection, leading.
On December 6, 2021, were you directed to go to the Wisconsin State Crime Lab to view a vehicle?
Objection, leading.
Overruled, the witness may answer. It's foundational. Go ahead.
Yes.
What information did you have prior to going to that location?
Objection, speculative.
Overruled, the witness may answer.
The information that I was given is that I was to set up an appointment there to look at a Ford Escape that had been involved in a crash in the parade in Waukesha.
Did you do a mechanical inspection of the vehicle that you were sent to look at?
Objection, leading.
Overruled, the witness may answer.
Yes, I did.
Did that report containing the findings of your mechanical inspection from December 6th?
Objection, leading.
Overruled, the witness may answer.
Yes.
I provided to you prior to you going up on the stand what's been marked as State's Exhibit 83. Can you briefly identify it for how it's labeled, how many pages it consists of?
What exhibit is that?
Exhibit 83.
It's the Crash Reconstruction Mechanical Inspection Report.
The whole report is exhibit 83?
Correct.
Yes.
The whole report?
Go ahead. I haven't ruled on it yet, so go ahead and ask your questions, Attorney Casey.
Sir, how many pages does this report consist of?
10.
And that is front and back sides?
Correct.
Objection.
What car were you inspecting?
Objection, leading.
Overruled, the witness may answer.
2010 Ford Escape.
And what color was it?
Objection, leading.
Overruled, you may answer.
The vehicle identification number on Exhibit 83, where did that information come from?
I always use the one inside the door jamb of the vehicle first, take note of it, and then cross-reference it with the public VIN on the vehicle to make sure that they both match.
And did they in this case?
Objection. I have the 10 pages and nowhere on here does it say it's an exhibit. Nowhere on here.
That's because it was marked for purposes of trial. It has an exhibit sticker now. So your objection's noted, it's overruled, and
Wow, I'm privy to the same.
the witness may answer the question. It's been marked as an exhibit.
And is there a picture on the front of Exhibit 83?
Yes.
Objection, leading.
Overruled.
And what is that picture of?
It's a picture of the 2010 Escape.
That you did the mechanical inspection on?
Objection, leading.
Overruled, the witness may answer.
Yes.
Is the information contained within this report accurate?
Objection, leading.
Overruled, the witness may answer.
Yes, it is.
I would move State's Exhibit 83 into evidence.
Objection.
Your objection's noted. It is overruled. Exhibit 83 is received.
So is my paperwork ever gonna say exhibit 83, or is it just gonna be this?
Mr. Brooks, I'll take that up outside the presence of the jury later, but we're going to continue.
It was
Go
brought
ahead.
up in front of the jury.
Mr. Brooks, we're going to continue with the questioning of this witness.
What is y'all trying to pull over there?
Mr. Brooks, please. No one's, the exhibit, to my understanding, has previously been provided to you. You have it. It's now been marked as an exhibit for trial
Y'all got
purposes.
something I don't have though.
Go ahead.
That's not how it's supposed to work. It's supposed to be fair.
Attorney Basie, I trust that this was previously turned over.
It was, and I believe the defendant has a copy of it in front of him.
Thank you.
Where does
Please
it say
continue.
exhibit 83? It doesn't say that this was going to
Again,
be
we'll take
used
this
as
up
an
outside the
exhibit.
presence of the jury later. It's not something we need to do right now. Go ahead, ask your questions.
Thank you, Your Honor. And I would object and move to strike from the record any commentary that the defendant was making in the last 5 minutes.
What was that?
Court will strike the commentary that was made. I'm not sure if it was picked up or not.
So the first section of your report, and I'm just going to direct your attention to page 3 of Exhibit 83, talks about the tires and the suspension and tie rods. Do you see that?
Objection leading.
Overruled. The witness may answer.
Yes.
And can you describe for the jury what part of the inspection, describe this part of the inspection?
Objection leading.
Overruled. The witness may answer. The report's been received by the court, and the state may direct the witness to various points at its discretion.
And when was it made an exhibit? Because I wasn't aware of that.
Sir, can you describe the information contained in the first section of the report under the heading tires, wheels, steering, suspension, brakes?
Objection leading.
Overruled.
There was a little bit of play in the tie rod, still attached, still intact, still functioning, still able to steer the vehicle, but just worn to the point that it needed replacement before it got any worse.
Is that something that would create any problems in operating the car, for example, on November 21st, 2021?
Objection speculative.
Overruled. This witness may answer. Hold on. He's been qualified under 907-02. I direct your attention to 907-02 through 907-07, Mr. Brooks. Go ahead.
I don't consider the vehicle on that name, and that's referring to a specific date. How do we know that's not speculation?
The objection's noted. It's overruled. The witness may answer.
It would not. The vehicle would still steer and drive just the same as any other vehicle. It would just have play in the steering wheel, and it would make a little bit of a clunking noise potentially when you turn the wheel. You would maybe hear a clunking noise from that left front tire rod.
If I didn't ask you this, the information you were provided was that this vehicle was involved in a crash?
Objection, ask and answer.
Overruled, given the nature of the testimony being provided, the state may clarify that. So go ahead, you may answer.
Yes.
And do you know the date of that crash?
I know it was in November. I don't know the exact date.
Okay, thank you. So with regards to the braking system, was there anything, did you find anything at all in your inspection of that vehicle that would have caused the brakes not to work or not to work effectively on the date of the crash or prior to the crash?
Objection speculative.
Overruled. The witness may answer.
No, I did not.
Actually, since your inspection took place after the crash, would that be your same answer with regard to, as it was on December 6, 2021, there were no brake problems?
Objection speculative.
Overruled. The witness may answer.
That is correct. The brakes still functioned at the time of inspection fully.
And the curb weight, what is that? I mean, generally, what is it now?
Objection leading.
Overruled.
If someone had reported hearing a clicking sound while this car was driving in front of them, was there anything that you found in your report that would be consistent with a clicking sound being heard?
Objection hearsay.
Overruled. The witness may answer.
It would be impossible to say if there would be a clicking noise from this vehicle. I was actually not able to drive it physically to test it. I was only able to just start it.
Can I ask why you were unable to drive it?
Objection relevancy.
Overruled. The witness may answer.
There's actually two reasons I was unable to drive it. One, again, with DNA evidence on the exterior of the vehicle. Two, there wasn't enough gas in the vehicle to move it.
Okay. So the car was on empty when you observed it?
Objection leading.
The same is to the form of the question.
How much gas was in the car when you inspected it?
Objection leading. Ask and answer.
Overruled. The witness may answer.
There was, the gauge read E for empty.
When you turned the key, what observations, if any, did you make?
Objection leading.
Overruled.
I want to show you what's been previously admitted, Exhibit 73. It'll show on the screen in front of you, and I'd ask that it be published as well.
Objection leading.
What is depicted in that photograph?
Objection. Speculative.
Overruled based on his training and experience. The witness may answer.
That it appears to be an exhaust muffler and a couple chunks of wood and overturned dirt.
The muffler that's observed in this picture, would that be consistent or inconsistent with a 2010 Ford Escape?
Objection speculative.
Overruled. This witness may answer and provide an opinion. Go ahead.
By just looking at a picture.
Overruled. The witness may answer.
Y'all think y'all.
You can cross-examine the witness about that, sir. Go ahead.
Y'all trying to pull a fast one.
It is a vehicle muffler. Without seeing the ends of it and where the inlet, outlet are, and actual measurements, it would be impossible to see what vehicle it came from, but it is an automotive muffler.
Do you check to see if there are any recalls of a vehicle in coming to your conclusion?
Objection speculative, and do we still need this exhibit?
Thank you. We can take that down, and your objection's noted. It's overruled. The witness may answer.
I do check for recalls, yes.
Now, you talked about the brake system in terms of the brake pedal within the car, and it's that was operating correctly. Do you recall that testimony?
Objection leading.
Overruled. It's foundational. The witness may answer.
Yes, I do.
How do the brake pads, where are they located, and how do they relate to the pressing down of a brake pedal?
Objection leading.
Overruled. The witness may answer.
Are there any other components to the braking system in a car?
Objection leading.
Overruled.
There's a parking brake system in the vehicle.
But other than that, so you've covered every aspect of the braking system in this particular vehicle, is that correct?
Objection speculative.
Overruled. The witness may answer.
Yes, I have.
Did you observe anything at all that would have prohibited this vehicle from stopping if the brake pedal had been applied?
No.
Is there anything that you observed or documented with it during or in your mechanical inspection report that would have contributed to the crashes that this car was involved in?
Objection has an answer.
Overruled. The witness may answer.
No.
Thank you.
Any cross-examination?
During your inspection, did you see any bullet holes?
Yes, I did.
Do you recall where? Back up. Do you recall how many bullet holes you observed?
I do not recall a number of them. No, I knew there were more than one.
The ones that you observed, do you recall where they were?
I do believe one might have exited through either the windshield or rear window, and one was in the side of the vehicle, if I remember correctly.
And did you find any shell casings?
No, I did not.
Now, you made reference to the left rear tire being bigger than the other tires.
Yes.
Can you give a little bit more clarity on how that would affect the vehicle?
So one larger tire on the vehicle would obviously make the vehicle lean ever so slightly away from whichever side is larger than the other. In this case, the amount of difference between the two tires, it's about 1.5 inches in difference in radius. So in radius, you get half of that amount in height. So it would be about 3/4 of an inch difference in height. That amount of difference is not noticeable in a vehicle. The other thing, each vehicle acts differently with different size tires on it. There's no one size fits all.
So different vehicles act differently to having a bigger fitting tire.
Yes.
you made reference to it, to a vehicle leaning away from the side that's bigger? Or
Correct.
would that in any way create a slight pull to the vehicle, to either side?
In my experience, that small amount would not, no.
I don't remember exactly what you said referring to the high beams. I guess you made reference to them being used at some point.
The high beams were activated when I did my inspection, meaning that when the headlights are on, they were in high beam mode. The selector stick was pressed forward.
Why would a vehicle use high beams?
Usually a driver uses high beams to see better or to illuminate things better.
So that would primarily refer to if it was nighttime?
Correct.
Would you say, with your expertise, it wouldn't make sense for a vehicle to use high beams in the daytime?
There are limited uses for them in the daytime, yes.
And what are some of the uses from your knowledge?
The high beams shine brighter, so even with sunlight shining on them, other vehicles can see them. It's a thing that we use on the highway as law enforcement sometimes. It's just a little bit of the thing to help oncoming vehicles see.
So it would essentially be for identification purposes.
For visibility is what I mean, so that it stands out to the other traffic. It doesn't look like it belongs because the lights look very bright. It gets the other driver's attention, the same as the red and blue lights on the top of the cars.
Gets them to notice that law enforcement is present.
Correct.
That's what I meant by ID purpose, for them to be able to see the ball joint and tire rod. Is there a difference between the two?
Yes, the ball joint is the joint itself, and it's on the end of the tie rod.
Did you notice anything wrong with the tire rod? The actual tire rod, not the ball joint?
No, there was nothing wrong with the tie rod.
I'm assuming you still have the exhibit 83?
Yes, sir.
It says, I noted a worn tie rod end on the left front wheel end. Was that in reference to the ball joint and not the tie rod?
Yes. They're one and the same. The tie rod end is a ball joint. It's two different ways to refer to the same component.
Okay, clarity. It doesn't say ball joint right here. Would that be fair to say?
Correct.
And what is the high mount brake lamp?
The high mount brake lamp is on the back of the vehicle. You have the right brake light and turn signal, left brake light and turn signal, and then there's the third brake light that's up, like usually in the rear window or at the top of the back of the hatch of the vehicle. That's the high mount brake lamp.
Okay. And it was inoperable when you inspected it?
That's correct. Both of those were inoperable during inspection.
So they didn't work?
Correct.
So it'd be fair to say if someone was viewing the vehicle from behind, they wouldn't be able to see because those were inoperable.
Yes, at the time of inspection, those lights did not work.
And you also stated that it is unknown if they were working prior to the crash or damaged during the crash. That'd be fair to say?
That's correct.
That you would know either way.
No, I would not have a way to tell when that light bulb went out.
Exactly, so that the rights and high mount brake lamp were inoperable. Do you recall that?
Yes.
How about the left's brake lamp? Is that operable or inoperable?
Objection. Leading.
Overruled, the witness may answer.
The left stop lamp was working.
No, sir, just going back again to this ball joint, you stated that, I guess, was your testimony and cross-examination that unless the ball and socket is separated, you can still safely operate that vehicle?
Objection. Mischaracterizes what was said.
Based on the form of the question, I'll allow the witness to answer.
Yes.
Does the engine control acceleration?
Objection. Relevancy.
Overruled, the witness may answer.
No, it requires driver input.
Does the engine control braking?
No, it does not.
Does the engine control steering?
Objection. What is the relevancy?
Overruled, the witness may answer.
No, it does not.
Does the engine control gear shifting?
Objection. Relevancy.
Overruled, the witness may answer.
It does not.
Actually, coolant or some type of water. I wasn't sure if you're talking about the water pump or the radiator. Do you know what was leaking, if anything?
Objection. Ask and answer during cross.
Overruled, the witness may answer. It's redirect.
Yes, so water pump, water coolant, it's all interchangeable as far as the cooling system for the engine goes. And the coolant system was low at the time of inspection and had been leaking, but from where I do not know.
And again, does that control the steering,
No,
the braking,
no,
the acceleration?
no.
Finally, sir, you had talked about on cross-examination the presence of the high beams being on during the daylight. Do you recall that line of questioning?
Yes,
Specifically, you had indicated that sometimes the state patrol uses their high beams during the day. What was that for?
Objection. That was answered.
Overruled, the witness may answer. It's redirect.
to increase visibility.
Is that of any assistance if a vehicle is coming up behind people?
Objection. Speculative.
Based on his training and experience, I will allow him to answer.
No.
Thank you. Nothing further.
All right, thank you. You may step down. I will take that. Thank you, sir. And once the witness passes, I'll excuse the jury for an afternoon break. It's just about 3:06. We'll take about 15 minutes. I'll rise for the jury. You can be seated. Mr. Brooks, I know the last thing you said, I heard you say that's hilarious. What were you referring to?
I was referring to, like, are you serious? Some of the same things that I ask on when it's my time to question a witness can be overruled. But when the same thing is done and I object, it's nothing. It's just thrown. It's just thrown to the side. I just think that's funny.
Well,
I
sir,
really do.
I don't find it funny. The objection to not having an exhibit sticker on your report is not, would not prevent the court from receiving the exhibit. And for my position, there's direct examination, there's cross-examination. The state or any witness, any party that calls a witness always has the opportunity to ask the direct exam questions and then redirect based upon what's asked during cross-examination. Sometimes that does mean there's some repetition, but I didn't see anything through the redirect of this witness that I thought was improper. So I just wanted to make a record of that. I am going to caution you, sir.
Do you understand what I was saying?
But during multiple times during the questioning of that witness, you were mumbling under your breath. You say disparaging remarks toward the court, toward the witness, or toward the process.
So if it was disparaging, what did I say?
Sir,
Because I
you
don't-
say things like it's not fair, or you make noises that suggest like you're disgusted with the ruling that is made.
So you're assuming what I mean by that, and when did I say
Mr.
it
Brooks,
wasn't
I'm
fair?
just making a record because
Yeah, but
it's
you're making
important
an
that,
incorrect record.
it's important that you demonstrate courtesy and decorum through these proceedings, and that you give respect to the witnesses who are testifying in the process.
Did
As
the
you-
witness feel disrespected? Did the witness say anything about feeling
Mr. Brooks,
disrespected?
I'm not gonna engage in this
'Cause I don't think he
back and
did.
forth with you, because first of all, it's a mischaracterization of my observations, number one, and
Yeah,
number
but
two,
your
it's my
observations are
job.
incorrect.
It's
If
my
it-
job to ensure that under 90611, that there's the effective presentation, and I'll just refer you to that once again. I'll read it into the
You
record.
don't need to read it.
Under
You don't need to read
906,
it. Just make sure that you make a
the
correct.
judge shall exercise reasonable
Don't lie on the
control over the mode and order of interrogating witnesses and presenting
it's
evidence
gonna get
with
addressed
all of
every
the
time.
following. Make the interrogation and presentation
Every time.
effective for the ascertainment of truth. And when leading questions may be used to develop the witness's testimony. So with that, we'll take our break. I'll start the 15 minutes. It's 3:13. We are in recess. Thank you.
Matter of fact, one thing on record.
Go ahead.
Okay. I did,
Actually take note of, when the court overruled one of, Mr. Brooks' objections, his,
know
response
consent to being
was,
called that name,
stop
you're right."
trying to be slick.
Yeah, I did say that.
So, just for the record, I thought that was very disrespectful.
Thank you. I would agree.
Judge, can we discuss scheduling at some point as well, either now or on the
When we
return?
come back.
Why wasn't that addressed, right when it happened?
Honestly, Mr. Brooks, I'm really trying hard not
Because
to
that's
highlight
the
your
definition of trying to
misconduct
be slick.
during the trial, and trying my best here to
I don't see
frankly
that.
minimize
I don't
pointing
see
those
it.
things out to the jury and instead pointing
don't
them
see it.
out outside the presence of the jury. You may have noticed I've even started to say I'd remind the jurors that the comments of the parties or the attorneys are not evidence, so as to cast a broad brush and not simply highlight your
I
conduct.
haven't noticed anything, and I don't.
But all right, we're in
refer to
recess. Thank
What
you.
conduct you referring to? If you're gonna be biased, then somebody. How late do we plan on going?
I will go as late as 6 o'clock if need be. So I want to keep pushing along. I want to,
Yeah, that's definitely pushing it.
that's not that late, sir. We've stayed till 5:36.
Okay.
Previously, there were times during jury selection, we stayed till probably 7 or 7:30.
In my
The last
position-
2 nights, we did break at about 4:30, 4:45, and so, I'm willing to go a little bit later tonight. So it's 3:30 now. We'll see how things go.
I was making that saying that on the record because in my position, that is kind of late.
Well, let's start now and we'll get going, and maybe we don't have to go that late. So bring the jury out.
Are we gonna address subject matter jurisdiction?
The written decision that I previously entered is what I will stand on. I'm not going to address it any further.
Is that verified proof?
Sir, my written decision is the decision on
Is it-
subject matter
Is it
jurisdiction.
verified proof? Because it hasn't been proven on the record, and that was not verified proof. It has
I
yet to be
am
proven.
denying the request by the defendant to verify subject matter
It
jurisdiction.
has
That's
to be
denied.
proven for the record.
I disagree with you as a matter of law. The
Show-
jury's coming
show me
out.
Lawful law.
All right, for the jury.
Show me by lawful law. Unless you make an tacit agreement that you don't have to prove subject matter jurisdiction on the record by law. It should be
All right,
proven.
welcome back, ladies and gentlemen of the jury.
Is there a set procedure you follow when you are asked to respond to a crime scene?
Yes.
What is that, please?
Just leading.
Overruled the witness stand.
If law enforcement is at the scene and would like the crime lab crime scene response team to respond, they simply call the lab that's in their jurisdiction, and basically the call will get routed to me and I'll dispatch a team to the scene.
And on November 21 of 2021, was the crime scene response unit asked to respond to an incident in the city of Waukesha, county of Waukesha, state of Wisconsin?
Yes, the nature of the call was to respond to an address on Maple Street to begin processing a vehicle that was abandoned in the driveway of that residence.
Were you given any limited information as to the significance of the vehicle?
Yes, it was reported to me that the vehicle was more than likely involved in running through the Waukesha Christmas parade.
Were you aware that it was reported pedestrians had been struck during the event?
Yes, that was reported.
The objection is noted. I'll allow it as it is foundational. The witness may answer.
Yes.
Now, when I think of a crime scene, I typically think of a place or a location. Does your unit also cover processing of a vehicle like this?
Yes,
Overruled, you may answer.
in this particular circumstance or situation, the vehicle itself can be considered a crime scene in and of itself.
And in your years with the crime lab, do you have prior experience processing motor vehicles that were suspected to have been involved in fatal collisions with pedestrians?
Objection, leading.
Overruled, foundational. The witness may answer.
Yes, I've processed several vehicles related to that.
So first on the screen is Exhibit 67, which I believe was previously admitted? Yes.
Yes.
All right.
Objection.
Prior to the photographing of the vehicle, has it been moved or altered by you in any way, sir?
No. Objection, leading.
Overruled, foundational. The witness may answer.
No.
Please put up for the witness number 68, which has been previously admitted.
Go ahead.
Objection.
Overruled.
Please describe.
This is a overall photograph of the back end of the red Ford Escape.
Do you believe these 5 photographs are true and accurate depictions of the way the vehicle looked on the driveway at 338 Maple that evening, sir?
Objection, leading.
I'm sorry, I was trying to get a hold of my witness list. Could you re-ask the question?
Yes, Your Honor. Do these 5 photographs truly and accurately depict the way the vehicle looked at 338 Maple Street on the evening of November 21, 21?
Objection, leading.
Overruled, foundational. The witness may answer.
Yes.
Move to admit 67, well, 67 and 68 are already in. So move to admit 93, 102, 103, and permission to publish all 5.
Objection. Relevancy.
Noted. Overruled. The exhibits are received. Permission to publish granted.
67, you testified was an overview photograph?
Yeah, it's an overall photograph of the...
Overruled. They're now being shown to the jury. It's proper. It's foundational as well. Go ahead.
Yes, this is a overall photograph showing the location of the vehicle, but specifically also showing the front end damage of the vehicle.
All right. Next, 93. Please describe.
A close-up.
Overruled. Go ahead.
A close-up of the damage that has been sustained on the front hood area, bumper area of the red Ford Escape.
Next is 68.
Objection.
Overruled.
There appears to be some liquid substance on the ground. Do you see that, sir?
Yes, I
Objection,
do.
leading.
Overruled, foundational. The witness may answer.
Do you remember seeing that substance that night?
Yes.
Were you able to tell what it was?
Objection, speculative.
Overruled. Based upon his training and experience, he may answer.
Not specifically what type of fluid it is, but some kind of engine compartment fluid.
From this vehicle?
Yes.
Okay. Number 102, please.
Also showing what I describe as a white headband on the broken driver door mirror.
Is that illuminated in some fashion?
Objection,
Yes.
leading.
Overruled.
How was it illuminated?
Objection, leading.
Overruled.
It has white LEDs that are within the cloth and they're blinking on and off.
Okay. And then last would be 103.
Objection.
Please describe. Oh, I'm sorry, he objected.
Overruled.
My processing strategy this particular night was to collect anything that would be fragile in nature off of the vehicle and then get it transported to a more environmentally friendly secured facility to continue processing in the subsequent days.
Was that for your comfort or for some scientific reason?
Objection, speculative.
Overruled.
So what items, if you recall, did you remove that you had deemed fragile?
Objection, leading.
Overruled.
Of particular interest on the vehicle was the headband that was around the driver door mirror that was broken.
So that item was removed?
Correct.
What about the front bumper? We saw that laying on the driveway. Was that secured in some fashion?
Objection, leading.
Overruled. You may answer.
Yes, to make transport easy, the bumper would have had to be lifted up with bungee cords and resecured.
I'm going to present to the witness only another series of photographs, starting with 105.
Go ahead. Do you know how many?
8.
Sequential?
Yes, 105 through 112.
Thank you.
Objection. Relevancy.
Well, I haven't seen them yet, so I'll have to wait, but you can put them up and then I'll make a ruling.
I think we're ready on our end. We're just waiting for Madam Clerk.
Oh, sorry. I'll leave it alone. We had it just next to each other twice.
105.
All right.
There.
Given what I see on the screen, the objection is overruled.
I'm just going to ask the witness to look through these photos just as if he had them in front of him, and then I'll ask some foundational questions. Do you need more time to review that photo?
Objection, leading.
Overruled.
Objection.
Noted. Exhibits 105, 106, 107, 108, 109, 110, 111, and 112 are all received. Permission to publish granted.
So in this photograph, sir, is the, what's the condition of the front bumper, please?
Objection, leading.
Overruled. Foundational. The witness may answer.
The front bumper is secured in somewhat, should be its original position with those bungee cords that we previously talked about.
Okay. Next, 106, please. Was there an effort by you to try and match the pieces of the bumper to the frame of the body, or is that just the way it came together?
Objection, speculative.
Overruled. Go ahead. You may answer.
At this time, I was not trying to physically match anything together. It was just for the purpose of securing it for transport.
What is the position of the driver's side window in this photograph, sir?
The window is down.
Is that the way you found it?
Yes.
Objection.
Overruled. The witness may answer.
107, please. Please describe.
An overall photograph from the point view of the front passenger side of the vehicle.
Next, 108.
Objection.
Overruled.
Is that the way you found it?
Yes.
Okay. 109. Along the front passenger door and the rear passenger door, do you see anything remarkable?
Objection, leading.
Overruled.
Spanning the length of both doors is quite a significant scratch.
Have you seen scratches like that before in processing motor vehicles, sir?
Objection, relevancy.
Overruled.
I have.
What is that consistent with, please?
Objection, leading.
Overruled.
Coming into contact with another item.
Thank you. Number 110. Please describe.
An overall photograph showing the rear of the passenger side of the vehicle.
111.
Objection.
Overruled.
And then 112, please.
Objection.
Overruled.
And it looks like there's a substance on the exterior of the vehicle on the driver's side. Do you see what I'm referring to, sir?
Objection, leading.
Overruled.
Do you know what that item or substance was?
Objection, speculative.
Overruled, based upon his training and experience and his personal observation of the vehicle, he may answer.
And was it sprayed along most of the driver's side of the vehicle?
Objection, speculative.
Overruled.
Yes.
Okay. Move to omit 117, permission to publish, Your Honor.
Objection, relevancy.
Overruled.
Objection.
Overruled. Go ahead.
Do you recognize the object in Exhibit 118?
I do.
Do you believe this photo is a true and accurate representation of the object as you found it on the vehicle?
Objection, speculative.
Overruled. Your answer may stand.
This is a close-up photograph of the clothing items that were pinned to the windshield by the crumpled hood, and it was being held in place by that hood pinning the items against the windshield, as well as that wiper arm.
Okay. What did you find them to be?
It was a detachable hood from a jacket, as well as a winter hat.
And can you just point out on the touch screen which is which?
Objection, leading.
Overruled.
That's the hood portion, and that's the hat portion.
Okay, thank you. Did you find any U.S. mail or paperwork inside the vehicle?
Objection, relevancy.
Overruled. The witness may answer.
Yes, I did.
Were there any names associated with the U.S. mail or paperwork inside the vehicle?
Objection, relevancy.
Overruled. The witness may answer.
Yes.
What was that name?
Darrell E. Brooks Jr.
Was there an address, if you can recall?
Objection, relevancy.
Overruled. The witness may answer.
There was, but I don't exactly recall it.
Sure. Also on the table next to you, sir, is your report that I've marked as exhibit number 90. Do you see that?
Yes.
Wait. Placed on the table.
Go ahead, Attorney Opper.
Well, objection, how did it get on the table?
Your objections noted. It's overruled. Record will reflect that there's a copy of a crime lab report. It has an exhibit sticker, number 90, with the case number of this case. Handing it back to the witness. Go ahead, you may question.
How did it get on the table? Who placed it on the table?
Attorney Opper indicated she placed it there.
When did that happen?
Attorney Opper, go ahead, continue.
Did you author this report, sir?
Yes, I did.
If you review the report, would you be able to see the address for Darrell Brooks that was noted in the paperwork from the inside of the SUV?
Objection, I don't consent to being called that name.
Noted, overruled.
Yes, I would.
Please do that, sir.
Objection,
Overruled.
grounds for the overrule.
The witness may answer.
Grounds for the overrule.
Go ahead, sir.
The address for the pieces of mail that I recovered was 4014 North 19th Street, Milwaukee, Wisconsin, 53209.
Thank you.
Objection, that should be strike. When he asked the question, he said he didn't recall. So how can you force somebody to recall?
The witness's recollection was refreshed through the use of his report, which he indicated he documented the address. Your objections noted. It's overruled. The answer will stand. Go ahead. Next question, please.
Yes, and actually, if I could back up 1 minute and ask Ms. Gussie to put back up 117. Got to ask a question about 117.
Go ahead.
And if we could display it, please, Madam Clerk.
Nobody got to answer no questions.
Mr. Brooks, please refrain from interrupting. You'll have an opportunity to ask your
I have an
questions
objection
on
of
cross.
how stuff got to the table without my knowledge. That should be known. that should at least be noted for the record.
It was
I wouldn't
noted for.
I wouldn't be able to do that.
Your objection's noted, it's overruled. Go ahead, Attorney Otto.
So that needs to stop happening.
In
It needs
addition
be
to the
fair.
All right, I'm gonna excuse the jury.
Can't keep doing stuff without, it should be a fair trial. That's my right. You shouldn't be able to do things without my knowledge. And then pass it off to the jury like that's fair. They deserve to know that too.
The rest of you can have a seat as well. As soon as the jury's out, I'll make a record. Okay, Mr. Brooks, you are well aware that the reason
consent to being called
documents
that
are
name.
being put on the
I don't consent to being
witness stand
called that name.
are because this court indicated it would limit the movement of the parties due to your custodial status to keep things fair.
And I
You are
merely asked, how did it get there?
Sir, do not
I'm not
interrupt me or you will
I'm not
forfeit your
entitled
right
to
to be
know how it got
present in
there.
this courtroom.
So
Do
you're
not
holding me in
interrupt
contempt?
me.
Are you holding me in contempt?
I'm gonna make a record.
Are you holding me in contempt?
I'm not answering your questions.
So then you're not holding me in contempt.
Do not interrupt me again or you will go to the other courtroom.
Under what lawful law?
All right, he's interrupted me once again. We're gonna clear the courtroom. He's being disrespectful. I'll make a record once he moves. Unless you can promise me right now that you let me make my record without you interrupting me, sir.
You gonna make your record? You can make your record.
Then please don't interrupt me.
Don't hold me in contempt.
I've never said any such thing.
Removing me from the courtroom, Your Honor, is essentially holding me in contempt.
All right, no, you're forfeiting your right to be present under Illinois versus Allen.
I didn't forfeit
I'm
anything.
gonna start talking, and if he interrupts, then I will close this courtroom and he will be taken to the next courtroom. Mr. Brooks, you are well aware that the court made some pretrial rulings related to whether there would be, they can stay in, I haven't closed it yet, he's not interrupting me, whether the parties could approach the witness stand. And I did that because you're in custody and I'm not going to allow you to approach the witness stand while in custody. That is why various precautions have taken place to limit, frankly, that from happening. Throughout this trial, there was one instance at the very beginning of the case where I allowed the state to approach a witness. I corrected that. That hasn't happened since. We've had bailiffs take items up to the witness stand, or the items have been given to the witnesses, or they've been placed on the witness stand. That's proper. There is nothing wrong about that. Nobody's trying to pull a fast one over you. No one is doing something that's not permitted by this court, or frankly, under the rules of decorum and courtesy or the presentation of evidence in this case. Frankly, from my perspective, sir, your attempts and your comments are to try to dig in at this jury and to somehow create doubt about the presentation of this case or the fairness of these proceedings without the party, meaning the state, having an opportunity to refute, explain, or correct it. I've taken the jury out at this point to admonish you that any further mumbling under your breath or not recognizing when I uphold or sustain an objection, that I will take as a disrupting interruption meant to disrupt the proceedings. I'm not holding you in contempt. I'm well aware that that's one of my options. I choose not to do it for the reasons that I've stated on the record previously. All right, you can forfeit your right to be present at any point in time during this trial by your conduct under Illinois versus Allen. When it is disruptive, when it does not follow the simple rules of courtesy and decorum, I draw your attention once again to SCR Chapter 62, which has been previously provided to you, which is under the statute there. These constant mumbling and interruptions during the proceedings. I haven't made a record of them today, but I will now. Started at 9:01, then there was 5 at 9:02, 3 at 9:03, 4 at 9:04, 1 at 9:05, 2 at 9:05, 1 at 9:06, 3 at 9:08, again at 9:17, 9:27, 10:31, 1:05, there was talking over by you at 2:03, 5 interruptions at 2:14, 2:15, 2:17, at 2:19, audible muttering, 2:31, 2:33, what I would describe as inappropriate, like muttering under your breath, 2:35. At 3:06, there was a hilarious comment. At 3:11, there was what I would describe as arguing about the muttering and the irony of it all. At 3:12, there were 4 interruptions. At 3:37, more 4:09, 4:10, more mumbling. At 4:11, twice, and at 4:12, 9 different times. So I think I've made an ample record of the disruptions today. I've been abundantly patient with you. Again, as I stated earlier, I've even limited how I tell these things to the jury about how to disregard. And I simply say the jury is to disregard comments and statements made by the parties or the lawyers, as those are not evidence. So I'm warning you, do not interrupt again. If this jury comes back or when they come back and you do that, then you will be removed and you will forfeit your right to be present for the examination of this witness. Let's bring the jury back in.
Well, you might as well remove me then, because what you're doing is not fair. I can't even rebut what you're saying. I didn't interrupt you. I let you make your incorrect record.
Mr. Brooks, I'm bringing the jury out and we're continuing. We're gonna get through these witnesses.
And I'm not stopping you from doing
Through your
that.
behavior, you're not gonna delay these proceedings today.
I'm not trying to
We're gonna
delay the
continue.
proceedings, so I wish you would stop being incorrect on the record and saying what I'm trying to do if you don't know that. You don't know what I'm trying to
bringing the
do.
jury out, I'm not gonna argue with you.
Then don't. Because I'm not arguing with you either. I'm stating
You're
facts.
raising your voice, it's very
Because I'm tired of you always making a
yelling at
record.
me.
You're making a record of me trying to look bad. I know what you're trying to do. It's not gonna work.
I'm making a record of what's accurately.
You're
being
making
done
a record of incorrect statements. That's what you're doing. You're not making a record of
Mr.
not
Brooks,
being
I'm
able.
advising you to be quiet because the jury's coming back
You're
up.
advising me to be quiet? Is you telling me to be
I'm
quiet?
advising you to be respectful when the
Are
jury
you
comes
telling me
out.
to be quiet or are you asking me?
I'm asking you and advising
Okay,
you.
thank you for correcting that, because don't nobody tell me what to do. I don't tell nobody else what to do.
I'd appreciate.
We're
if
all
you lowered your tone
adults
of
in here.
voice
I've
and
never
not yell
told
at
you
me,
to do
sir.
anything at all.
Sir, I'd appreciate if your tone of voice would change.
I would appreciate if you would ask me. I'm a grown man with grown kids. Ain't nobody gonna talk to me like that. Nobody. I don't have a problem with doing what you ask me to do, not tell me. Just like when I asked you about subject matter jurisdiction that you have yet to prove on the record. But somehow I'm being intentionally disruptive. Come on, man, stop. Just stop it.
Jury's coming out.
All rise for the jury.
Not gonna work. I'm supposed to be scared of getting removed or something.
Thank you, everyone. Please be seated. Statement continuance, examination of this witness. I believe we're on exhibit 117.
Yes, we have 117. If Madam Clerk, would you please turn the display back on? Mr. Johnson, were there other items on the front passenger seat besides the blue winter hat?
Objection leading.
Overruled, the witness may answer.
I do recall a cell phone being present on that front passenger seat.
I also see some items that look like maybe headphones or charging cable, something like that. Do you see that, sir?
Objection leading.
Overruled, foundational. The witness may answer. The exhibits previously been received.
Objection speculative.
Overruled.
I do see that.
And how about on the floorboard of the front passenger seat? Is there an item there, sir?
Objection leading.
Overruled. You may answer.
Yes.
What do you remember that item was?
A TV.
Okay. Now, if we could please go to exhibit 116 and put up for the witness only. Sir, do you see Exhibit 116 in front of you?
I do.
Move to admit 116, permission to publish.
Objection, relevancy.
Overruled. Exhibit 116 is received, permission to publish is granted.
This is an overview of the rear passenger seat. That rear passenger compartment contained several clothing items and miscellaneous items.
Okay. Was the condition of the back seat like this when you found the vehicle, sir?
Objection, speculative.
Overruled. The witness may answer based upon his knowledge of recovering the vehicle from the scene and his training and experience.
Yes.
I'm going to please ask Ms. Gussie to put up 113, 114, and 115 for his review.
Go ahead.
113 up?
Yes,
Okay, do you recognize that item?
I do.
Okay. Move to admit 113, 114, and 115, permission to publish. Were you able to tell the path of travel for the bullet?
Objection,
Yes.
speculative.
Please describe.
Overruled. You may answer.
Yes. The fired bullet that caused this defect most likely came through that rear passenger window that was shattered and entered the vehicle and then exited the vehicle through the windshield.
Number 114, please.
That's an apparent fired bullet defect. I call this a striking defect. That's on the roof rail of the passenger side of the vehicle.
Okay. Why do you call it a striking defect?
It didn't penetrate any part of the vehicle. It was more of a glancing kind of ricochet.
Okay. And then number 115? And if you could zoom in on that back left. Yep, thank you. Please describe.
This is an apparent fired bullet defect. I call this a perforating defect because it actually went through the exterior door skin and went all the way through into the inside of the vehicle.
What kinds of things are you looking for on the undercarriage?
Looking for anything that shouldn't be normally present on the undercarriage of the vehicle. So I was looking for any hairs, fibers, any potential biological fluids such as blood.
Did you find any such objects?
Objection, leading.
Overruled. He may answer.
Yes, I did.
Did you collect those items?
Yes, I did.
You had described for us earlier swabbing of the steering wheel on the interior of the vehicle. Do you recall that?
Objection, leading.
Overruled. The witness may answer.
How do you go about swabbing a steering wheel, sir?
Objection, what's the relevancy?
Overruled. The witness may answer.
The best way to collect DNA evidence from a surface is to use a two-swab technique. In this particular case, those items, anything for DNA, is going to be transferred to the DNA analysis unit.
Did that happen?
Yes, that did.
And how about the hat, States Exhibit 87? Did that get transferred to another unit for further analysis, to your knowledge?
Yes, so any clothing item that's...
Hold on. There was an objection. Grounds?
Relevancy.
Overruled. The witness may continue answering.
Clothing items that are worn by individuals are a really good source of transfer of DNA. So yes, I collected that hat and it was transferred to the DNA analysis unit.
Your report, Exhibit 90, did you believe that to be a true and accurate narration or summary, I should say, of your work in this case, sir?
Yes, I do.
Move to admit number 90, Your Honor.
Objection, relevancy.
Overruled. Exhibit 90 is received.
I don't have any other questions then, Your Honor.
All right. Thank you. Cross-exam, please.
You said you do DNA analysis, correct?
No, I did DNA analysis for nearly 10 years. I don't actually do DNA analysis anymore.
So at the time of the incident, were you doing DNA analysis?
No.
So who did the DNA analysis on all the items that were found during your investigation?
DNA analyst Trevor Nailed.
Did you see the results of those DNA Did you see the results of those DNA tests?
We did have conversations.
Did you see them?
No.
So it'd be fair to say you don't know what those results were.
I didn't verify it. Like I said, we just had conversations.
So do you know the results of the DNA analysis?
In particular, is there a particular item?
For any of the items?
I don't recall the exact results, no.
And you made reference to the gunshot that you stated stayed in the rear cargo. Where in the rear cargo did you find that shell casing?
Objection, that's a misstatement. It wasn't a shell casing, Your Honor.
Shell casing, fragment, same thing.
Hold on, there's been an objection. I'll sustain the objection. It mischaracterizes the testimony and ask that you rephrase it.
Did you find a shell casing or bullet fragment?
I found a fired bullet fragment.
Where did you find the fired bullet fragment?
It was really close proximity to where the rear latch comes down and hooks in to stay closed. So on the floor of the rear cargo by where the actual cargo door comes down.
And you said a latch that comes down?
Yeah, so how doors latch, like car doors latch, you know where the latch is? So where the rear cargo door came down and latched, it was in really close proximity on the horizontal surface of that rear cargo area.
Did you observe if the bullet fragment had struck anything?
It struck some items in that rear cargo area.
Do you recall what it struck?
I don't.
You made reference to a headband being on the rear view driver's side mirror, correct?
Correct, it was on the driver's door mirror.
And from your expertise, how would you, in your opinion, guess that it got there?
By coming into contact with something or someone that was wearing it?
And do you know that for sure?
No, but based off of my experience of a lot of years of examination of physical items of evidence.
But it'd be fair to say that you don't know exactly.
No, I wasn't at the parade. I wasn't. No.
When towing the vehicle, what was it placed on?
Because of the amount of traffic or cars that were parked on the road, the towing company couldn't get the enclosed trailer right to the end of the driveway. So the vehicle was put onto a flatbed truck and then driven a few houses down, where then it was transferred to an enclosed trailer and then removed from the scene.
So with the bumper, being that it was first placed on a flatbed truck, as you say, at that time, what the bumper had, what problem would the bumper had caused if it wasn't going to be physically dragged or anything at that point?
I'm not sure I understand your question.
What kind of problem would the bumper pose if the vehicle was on a flatbed truck?
The whole point
Essentially what I'm saying is, to give you more clarity, how could the bumper be dragged at that point?
it was being removed from the surface of the driveway onto the flatbed. So if the bumper weren't secured in an upright position, it would be pulled, and the bumper, as the vehicle is going this way, the bumper would be pulled underneath the vehicle.
So once it was secured on the flatbed truck, would the bumper still pose any problem?
The vehicle on the flatbed, the bumper was in a secured position.
If it wasn't bungee corded, would it have posed a problem?
Yes.
How so if it wasn't moving?
The whole purpose was to secure the bumper in place to preserve any physical evidence that might have been on the bumper.
And do you recall who did the actual towing?
The company is Complete Towing and Recovery.
And you stated to want to get the vehicle to a environmentally friendly, secure location?
Yeah, a better term would be environmentally controlled.
What do you mean by environmentally controlled?
Proper lighting, outside of the elements, outside of view of the public, so an enclosed building.
Why the reference to outside of the public?
It's easier to do examinations in a controlled environment.
Would it be fair to say at that time, before it was towed, the vehicle had been secured, checked? That was done out in public, so what would be the difference at that point?
That night, I was concerned with doing the necessary steps that I deemed relevant to collect, and then get that vehicle to a more suitable environment, just based off of how much more work and analysis and processing that vehicle would entail.
Fundamentally, I follow what you're saying fundamentally. The question though is, by the time you arrived to the scene where the vehicle was located, were you aware that the vehicle had essentially been already investigated?
No.
So you had no knowledge that the vehicle had been secured, had been pretty much investigated by that point?
Well, I was aware that the vehicle was in a secured state. I don't know what happened prior to that. There was very little information that I received on the initial phone call because of the hectic nature of everything. So I had an address and I knew that the vehicle was being secured by law enforcement.
So law enforcement were present when you arrived to the scene?
Yes.
And at that time you had learned, did you learn any knowledge from the law enforcement other than what you were told during the phone call?
No.
Do you recall who you were called by?
I was called by Special Agent in Charge Dave Klabundy of the Division of Criminal Investigations.
Do you recall what time you arrived at the scene?
I arrived at approximately 8:15 p.m.
Do you recall what time the vehicle was found?
I don't recall.
Do you recall anyone telling you or mentioning what time the vehicle had been found?
I don't recall.
So it'd be fair to say before you arrived on the scene, you have no knowledge of what's been happening around the vehicle?
That's correct.
You say you made reference to a hat being found in the background. Do you remember saying that? Or in the backyard, rather. I'm sorry, not the background, the backyard, I meant to say.
Yes.
And at the time that you observed this hat in the backyard, do you, from your expert opinion, do you recall that having any relevance to the vehicle?
No, it was an item of evidence or a potential item of evidence that just seemed out of place. So in those types of situations, I always collect those types of items.
But you weren't sure at the time if it had any involvement with the actual vehicle?
No.
Was there anything significant that stood out about the hat?
Just the location.
Did you find any blood on the hat? Did you find, or is it just pretty much just a hat in the backyard?
I didn't do a thorough examination of the hat.
So as far as you were concerned, it was basically just taking in the evidence as a precautionary thing, or?
Yeah, it was an item that just seemed out of place, so I collected that hat.
All the photographs that you were shown, had you seen those photographs before today?
Yes.
Do you recall if they were taken the same night of your investigation or multiple nights or days, rather?
There were multiple days.
And do you recall why you had to, or do you recall why those photos had to be taken over a multiple day span?
Yes, the vehicle needed a comprehensive evaluation or processing examination of pretty much every single side and surface of that vehicle.
And to do that, photograph wise, would have took days?
Yes.
Do you recall how long your complete investigation took?
Mine along with my colleagues?
Yours.
Mine. The examination itself of just me examining the vehicle?
Just you.
Probably over 40 hours. And that does not include the report that I'm writing. It doesn't include the process of going through the report, everything. But my examination, at least 40.
And so I'm assuming you did the report after you completed the initial investigation.
Yes, the report's a summary of my processing.
And define summary. What do you mean by summary?
It pulls everything together. It details my examinations and any findings I have from those examinations.
I always view summary as not every detail, but pretty much like it's much as would be relevant, but not every single detail. Would that be fair to say?
This report is comprehensive in the terms of it lists every single item that was collected.
So why would you refer to it as a summary?
It's a summary of the examination and processing. That's the best way to describe it. It's not a dictation. In other words,
what do you mean by dictation?
There are other reports that other agencies may do that are dictated, right? I did this, then I did this, then I did this. This is a summary. This isn't a dictated report.
So what exactly did you summarize in your report?
My examination and processing strategies that I used, and the items of evidence collected, and any relevant findings associated with those examinations.
Do you recall obtaining a search warrant to conduct an inspection on the ACM?
I'm sorry, I didn't understand you.
An inspection of what?
The ACM, I guess that would be the air control module. I'm guessing that's what that's
Thank you.
referencing.
No, since I don't do that type of analysis or examination, I didn't obtain any search warrant with that.
Any reason why I would say that in the paperwork?
Objection vague.
Grounds.
Sustained as to the form of the question. As to what paperwork you're referring to.
I'm guessing, I don't know what it will be called, but it says conclusion inspection summary. And the conclusion inspection or conclusion/inspection summary. Do you
Is it
recall?
from this witness?
Huh?
Is it from this witness?
Yeah.
Okay, go ahead.
I don't think that is from this witness, John. I don't see anything like that in this Exhibit 90. Are you perhaps still looking at Inspector Schultz's report from the State Patrol, the last witness?
What page number do you have, and I'll take a look at it and my email compare it.
This says, page 5.
Yeah, he's looking at the last exhibit from Inspector Schultz, 83.
It says Chief Christopher Johnson.
Oh, it does say that in 83. It says, if I can read for completeness, or you can, it says, upon arrival, I met with crime scene chief Christopher Johnson from the Wisconsin State Crime Center.
No. That's not what I'm reading from.
Okay. Chief Johnson had obtained a search warrant to conduct the mechanical inspection and to image the data retained within the escape's airbag control module ACM.
Yes.
Correct?
Yes.
Okay. So that was written by Inspector Schultz, who just testified, not this witness, to clarify the record.
Thank you.
Had you received any follow-up from law enforcement after you had completed everything?
No.
Had you yourself followed up with law enforcement about the investigation after you completed your initial part?
No.
You yourself didn't file any claims in this matter, did you?
No.
Do you know of anyone who filed any claims in this matter?
I don't.
And do you recall who you were subpoenaed by to testify?
I was subpoenaed by District Attorney Sue Hopper.
Have you at any time seen or read any complaints in regards to this incident?
No.
Do you know who the plaintiff is in this matter?
The state of Wisconsin?
Would you label that as a person, an actual human? Grounds.
Sustained, not relevant.
You ever actually seen the plaintiff in this matter? Grounds.
Sustained.
If you saw the plaintiff, would you be able to identify the plaintiff?
Objection,
Grounds.
irrelevant.
Sustained pursuant to 9611, sir. Please move on to a different line of questioning.
Just trying to establish who the plaintiff is, Your Honor. Do you see the plaintiff present in court today?
Objection,
Grounds.
irrelevant.
Sustained.
Would you consider yourself to be an injured party in this matter?
No.
No further questions.
Thank you. Any redirect?
Just very briefly. Mr. Johnson, you said when you arrived on Maple Street, there were police officers present,
That's correct.
and you said the vehicle was secure at that point.
Correct.
Objection.
What do you mean?
Leading.
The answer may stand. Next question. Overruled.
What do you mean by that, sir?
The perimeter was secured with crime scene tape, and there were officers that were standing at the location where the vehicle was.
Would it have been possible for a member of the public or any curious person to just walk up and touch the vehicle or do anything to the vehicle?
Objection. Speculative.
Based upon his training and experience, he may answer. Overruled.
They would have been stopped by law enforcement.
Thank you, that's all I have.
All right, thank you, sir. You may step down. I'll put that back.
Thank you.
Objection to that.
Noted.
Before you showed me that, I didn't even see what that was. If you would have
I'll
never
show
told,
you again.
I know, but if you never would have told me, I never would have even know what that was, and I didn't see it till you just moved it.
The witness had it up on the stand, but here it is. It's exhibit, marked as exhibit 87. Go ahead and say, state has moved it into evidence. I believe there's an objection. It's
Yes,
noted.
there is an objection.
Overruled based upon the testimony of the prior witness. It is received. And who do we have coming up to the stand?
Your Honor, the state next calls Trevor Naled, and for the record, he was handed a copy of Exhibit 91 on his way to the witness stand. About how many DNA samples have you processed?
Objection.
Overruled. The witness may answer. I'm sorry, will you repeat your answer?
Over 2,000.
Have you previously testified in court before?
Objection relevancy.
Overruled. The witness may answer.
Where's DNA found in the human body?
Objection leading.
Overruled. Foundational. The witness may answer.
DNA is found in the nucleus of a cell.
And is that important in your analysis?
Objection leading.
Overruled. Foundational. You may answer.
Yes, it is.
Why?
Objection leading.
Overruled. Go ahead.
It's important because we can take samples, evidentiary samples that may be from blood or saliva, and compare them with known standards, which are typically buccal swabs, which are swabs from the inside of the cheek, or dried blood standards.
Are you familiar with something known as STR analysis?
Objection leading.
Overruled. Foundational. The witness may answer.
Yes, I am.
What is STR analysis, please?
For short tandem repeat analysis, over 99% of DNA is the same from person to person. So we're looking at that 1% that varies from individual to individual. We can type standards from anybody associated with the case and make comparisons from the evidentiary profile to the standards to either include or exclude individuals.
All right. I'd like to direct your attention to Exhibit 91. Do you have that item in front of you, sir?
Yes, I do.
What is 91, please?
91 is my confidential report of laboratory findings dated April 29th, 2022.
And do you know if it relates to events occurring in the city of Waukesha on November 21 of 21?
Objection leading.
Overruled. Foundational. The witness may answer.
Yes, it does.
Okay. Were you given DNA standards to compare any profiles that you may develop from the evidence to known individuals in the case?
Yes, I was.
Do you remember who you got standards from?
I do.
Are you able to name them, or if you need to refer to your report, you may, but just let us know.
Okay. Can I read off the report?
You may read off your report. What page are you reading from, sir?
I will be reading page 2.
Okay. Go ahead.
Objection.
Overruled. The witness may do so.
I received buccal swabs, so cheek swabs from Erica Patterson as well as Darrell Brooks. I received dried blood standards from Wilhelm Hospital, Tamara Durand, Jane Kulick, Leanna Owen, Virginia Sorensen, and Jackson Sparks.
Is there a difference between those two, the method in which they were submitted, the buccal swab versus the dried blood standard?
Objection leading.
Overruled. Foundational. The witness may answer.
Yes.
All right. Now you processed many items related to this case. Is that correct, sir?
Objection leading.
Overruled. Foundational. The witness may answer.
Yes, I did.
Analysis you were able to perform on some swabs from the steering wheel of the vehicle in question. Is that correct, sir?
That's correct.
And the swabs were obtained by another member of the crime lab. Is that right?
Objection speculative.
Overruled. The witness may answer.
That's correct. In this case, we were able to say that it was a two-person mixture.
Were you able to identify who those two people would be?
Objection speculative.
Overruled. the witness may answer based upon training, experience, and investigation and analysis in this case.
Yes.
How did you do that, sir?
I ran it through this program called StarMix.
Is that a computer program?
Yes, it is.
What is that, please?
Objection, leading.
Overruled.
How does it work?
Objection, leading.
Overruled.
Is that used in other labs around the country, sir?
Objection, speculative. Don't know it's used around the country.
Overruled. The witness may answer.
Yes, it is.
Is it a reliable method of performing DNA analysis, in your opinion, sir?
Yes, it is.
Has it been accepted in courts and other cases?
Objection, speculative.
Overruled. The witness may answer.
Yes, it has.
More than once?
Objection, leading.
Overruled. You may answer.
Yes.
Do you know about how many times StarMix has been used in Wisconsin courts?
Objection, speculative.
Overruled. The witness may answer.
Since we brought it online in January of 2020, it's been accepted over 100 times in the state of Wisconsin.
Do you use StarMix to analyze the DNA profile, this two-person mixture from the steering wheel of the Ford Escape?
Objection, leading.
Overruled. Foundational. The witness may answer.
Yes, I did.
What conclusion did you draw?
Based on it being a two-person mixture, Erica Patterson and Darrell Brooks are both very strong support for inclusion. They're both great, or it's at least 1 quadrillion times more likely to observe the DNA profile if it's a mixture resulting from them plus an unknown over 2 unknowns.
So the odds of it being Mr. Brooks' DNA versus some other random person in the world are very, very rare, correct?
Objection, leading, and I don't consent to being called that name.
Received swabs from the gear shift of the red SUV.
I ran that through StarMix as well.
And what conclusion did you reach?
Objection, leading.
Overruled. The witness may answer.
The same as the steering wheel. So Erica Patterson and Darrell Brooks are both very strong support for inclusion.
Meaning that their DNA is on that gear shift.
Objection, leading.
Excuse me. It's at least 1 quadrillion times more likely to observe the DNA profile if it's a mixture from H1, meaning the person of interest, and 2 unknowns versus 3 unknowns.
The person of interest being Darrell Brooks?
Objection, I don't consent to being called that name. It is leading the witness.
Overruled.
So in this case, both Erica and Darrell are greater than 1 times 10 to the 15th, which is our 1 quadrillion.
And the last item you said was a stain on the right cuff of the sweatshirt?
Correct.
Did you reach any ultimate conclusion as relates to that item?
That was a 2-person mixture with at least 1 male contributor.
And what was your conclusion?
Both Erica Patterson and Darrell Brooks are very strong support for inclusion.
You said that substance was a presumptive positive for blood?
Correct.
Objection, leading.
Overruled. The witness may answer.
That's correct.
These DNA analysis with StarMix, I'm a little curious to get clarification on what does it mean when you say mixture? What exactly does that mean?
A mixture just means that it is more than 1 person present in the profile.
So by it being more than 1 person present in the profile, would it be fair to say that that would constitute it being more than 1 person?
Yes.
The gear shift had a 3-person mixture, so would that apply to the gear shift the same, that it would likelihood there's 3 different people's DNA on the gear shift?
That's correct.
And for the steering wheel, a 2-person mixture, so that would be 2 people for DNA for the steering wheel?
Correct.
Do you recall when you did this DNA analyzation rather? I'm sorry.
On any specific item or all of them?
Do you recall when you did all the items, I guess?
So most of the items were collected in November. They were not transferred to the Madison lab until the end of January. So I started, I believe January 31st was the first day that I started analysis. And then my report was written April 29th.
So you started the analysis at the end of January?
Correct.
And you did your report in April? Why so long?
I generated 583 pages and my report's 15 pages long, so that takes a little bit of time.
So you broke down the 583 pages into 15?
Correct.
Do you know where the items were kept prior to you receiving them?
Yes.
Can you state for the jury and for the record?
Our evidence technicians, when they came to the Madison lab, put them into storage where all evidence is stored.
Were the items sealed like they are now?
Yes.
And so I'm assuming you had to unseal them, get them out of the sealing packages to do the analyzation. Would that be fair to say?
That's correct, yes.
Did you repackage the items after you were done yourself?
Yes, sir.
And did you return them back to where you had received them from, or did you keep them at your, I think you said the Madison lab?
I'm based out of the Madison lab, yes. Typically, when we're done with evidence, we will return them to our evidence technicians, who will then put them back into storage. When the case is done, the evidence is then returned to the submitting agency.
So the items are still at your lab, is from your knowledge?
Now?
Yeah.
No.
Well, I asked that, let me give you some clarity. I asked that because you said at the completion of the case, they would be returned to the agency that you received them from. So I was kind of trying to get clarity on that. So do you know if they were returned to the agency you received them from already?
I believe they were.
So it'd be fair to say in this situation, the items weren't continued to be stored at the Madison lab.
That's correct.
A lot of these DNA analysis, I noticed that specifically DNA was analyzed for 8 people. Would that be fair to say?
Sounds right, yes.
One of your analysis had a 4-person mixture. Were you able to determine out of the 8 DNAs that you ran if any of those DNAs were found on that specific item?
Your Honor, I object that it's vague. I'm not sure which item he's referring to.
I'm referring to, it says brim of maroon winter style hat.
What page are you on, please, sir?
6.
Correct, so you want directing the witness to page 6?
Yes.
That particular
Yes,
item?
that's where I'm reading from, yes.
Okay, thank you. Did you ask the question?
Yeah, I said, this one, in particular, the one I'm referring to, has a 4-person mixture. Did your analysis identify any one of those 4 people out of the 8 DNA samples that you were analyzing?
No, it did not.
Would it be fair to say for pretty much all the items that you did analysis on, there were at minimum 2 or 3 person mixtures?
No.
And why would you say that?
Typically in our reports, we lump the star mix samples together. If you look before that, it will have items that were single source profiles.
That's why I said the majority of, or if not all. I didn't say every single one.
I wouldn't say the majority, no.
Certainly looks that way. Would it be fair to say that page 13, 12, 11, 10, 9, 8, 7, and 6, out of all those pages, only 3 have single source, and all the rest of them have at least 2 or 3 mixtures. Would that be fair to say?
No.
And can you point out where the inaccuracy may be?
Sure.
In case I'm not being accurate?
Yeah, on page 6, the first profile that you're looking at, cuttings of the apparent hair from the gas tank strap, that's a single source profile.
That's 1.
The next line, the cutting of the unlit end of the blunt is 1.
2.
Cuttings of the apparent roots from the hairs, which is CC4, CC5, and CC8. So that's 3 items right there.
So you're looking at the actual heading?
That's correct.
And is that it from?
On that page, yes.
Any other pages?
Which direction is the books, forward or backwards?
I don't consent to being called that name. We're going from page 6.
Are you asking single source profiles?
To page 7. From page 7, do you see any single source? Or yes, I guess it would be called single source.
No. From page 6 to 13, as you previously stated, those are my star mix ones. So each one of those is going to be a mixture profile.
So the majority of them have mixture of persons.
From those pages, yes, but there are many single source profiles before the star mix conclusions.
Do you recall who you turned your report over to once you finished your report?
For technical review?
I'm sorry, can you repeat that?
For technical review?
I'm referring to once you had finished your written report. Do you recall who you turned that over to?
Yes.
Can you state it for the jury and for the record?
Kelly Gajewski was my tech reviewer.
Can you spell that last name for the record?
It's Gajewski, Gajewski.
Thank you.
And do you know what happened to the written report from that point?
After she reviews it, sent it back for edits, and then I fixed those. It was approved by her. Then it goes to a supervisor for an administrative review.
Fix the edits? What do you mean by fix the edits?
If there's any typos or anything like that, it'll come back. Or if I forgot to initial a page or something like that, I'll fix those and then send it back to her for approval.
Working with law enforcement, which you've stated you've done numerous times. And in regards to written reports, to your knowledge, are you aware of officers taking a creative writing course?
Objection, relevant.
Grounds.
Sustained. That's the fourth question.
Have you yourself ever taken a creative writing course?
Objection, relevance.
Sustained, not relevant. Next question.
Have you or anyone you know filed a complaint in this matter?
No.
Would you consider yourself an injured party in this matter?
No.
Ever directly talk to the plaintiff in this matter?
I don't know how I would talk to the state of Wisconsin.
Can you repeat that? I'm sorry.
I do not know how I would talk to the state of Wisconsin. It's an entity.
Not a person, right? No further questions?
One of the items you described as items CC4A, CC5A, and CC8A. Do you see that?
Objection, leading.
Overruled, the witness may answer. Go ahead.
Yes, I do.
What do those items represent?
Objection, leading.
Overruled, the witness may answer.
Those are cuttings of the apparent root ends of the hairs that I took off the sweatshirt.
I forgot to ask you about the hairs.
Objection, leading.
Did you, I'm sorry, that was a statement. I'll move on, Your Honor.
Thank you.
You told Mr. Brooks on cross that you developed a single source profile for those hairs. Is that right?
Objection, I don't consent to being called their name, and it's leading the witness.
The objections are noted. Overruled, the witness may answer.
That's correct.
Who was the source of those hairs on that sweatshirt, State's Exhibit number 84?
Objection, speculative.
Overruled, go ahead and answer.
Darrell Brooks is the source.
Thank you.
As much as I would love to have another witness, we're going to break for the night because it is 5:49. So, with that, I will give the instruction that I've been giving every night. Do you have any idea how long you anticipate your opening will be?
Opening statement?
Yes.
I don't think it's any way to gauge how long it will be.
Just be mindful, sir, it's not the time to make argument, opening statements, as I like to call them, and what the jury instruction references, it's the roadmap. So I will expect to hear a lot of the evidence will show, the testimony, things of that nature. If it turns into argument, that's what happens at the close of the case.
What do you mean by argument?
If you're trying to argue the evidence and what it means,
No, I'm not trying to argue.
but this will be what, basically to lay out what the defense, what I would expect is for you to lay out what the defense or defenses that you believe you'll be presenting evidence about will be. To kind of, again, give the jury a roadmap, an idea of what to expect as your witnesses come forward. And then at some point, I don't know whether you will make a decision to testify or not, but we do have to have a conversation on the record about that. So if you could just give me an idea, if you are going to testify yourself, if you think that would be at the beginning or at the end, so I can gauge when to have that conversation with you.
I don't know for sure yet at this point.
Fair enough. So At some point, I'll have that conversation with you, though. All right, we'll see everyone at 8:45 tomorrow. All right, good morning, everyone. The court will call State of Wisconsin versus Darrell Brooks, case number 21 CF 1848. May I have the appearances, please?
Good morning, Judge Schlepper, Leslie Basie, and Zach Witchow appearing for the state of Wisconsin.
Good morning, sir. Please state your name for the record.
Just 1 second. Make sure I have everything since Dave's coming late today. I'm here as a third-party intervener in that matter, appearing as authorized representative for my client. I accept for value in return for value all of the charging instruments in this matter and make my exemption available for the discharge of all obligations and charges connected with this case. I do not dispute any of the facts in the charging instruments and do not consent to being called that name for the record.
All right, thank you. That is noted. The record will also reflect that the individual known to this court as Darrell Brooks is present in person in custody. He is wearing street clothes, specifically a suit and tie and a mask as well.
And don't consent to being called that name.
I understand, sir. All right, I do want to put on the record I gave the parties this morning. It's an excerpt from a judicial bench book on opening statements. It's about a page and a half. I thought it would be helpful to provide to Mr. Brooks as he puts together his opening statement. I'm going to further advise you at the time when you do make your opening statement that it not reference subject matter jurisdiction. That is, despite what I know you believe to be to the contrary, it is not a requirement to be proven in this case. It is not a factual or legal argument that is accurate, and therefore I'm prohibiting you from referencing that during either opening statements or closing arguments. With that, I believe
For the record, is this the what you're referring to?
The page and a half is from my judicial bench book. I thought it would be helpful to you so that you have a better awareness and understanding of the manner and purpose of an opening statement. This is what guides me as I preside over cases.
Okay, I accept for value in return for value these documents. I don't know why the reference to subject matter jurisdiction in the opening statement. I'm pretty aware that wouldn't be part of an opening or closing statement. I don't.
Okay, great.
I don't get why that's
I wanted to make the
relevant.
record clear. So I appreciate you indicating to me that you're aware of that.
Even though subject matter jurisdiction has not been proven on the record and should
Sir,
be
it does
addressed.
not need to be proven on the record. It's established by law and by the fact that, as my written decision indicates, commenced when the criminal complaint was filed in this case. It's conferred by Constitution and by statute.
And who was the complaint filed by? Because subject matter jurisdiction has yet
I'm
to
not
be
going to go
proven on
down
the
this
record.
path today. I'm just advising you, you cannot reference that in your opening statement.
That was something I've already had the common sense to know, but also subject matter jurisdiction has not been proven for the record.
All right, next topic then. I believe the state has
Should be
filed a
proven for the
motion.
record by the prosecution.
Objection is noted. It is not legally sound. It's overruled.
It's definitely legally sound.
All right,
Has yet to be
Attorney,
proven.
I'm going to turn to Attorney Opper. They filed a motion this morning. Has it been pulled through? I probably just need to refresh, but Madam Clerk.
It was served on Mr. Brooks last night in the jail, Your Honor.
All right, go ahead. You can make.
I didn't look at the document. I accept for value the document. I didn't look at it. So I don't know what I'm I'm supposed to say to that.
All right, well, Attorney Alpert, it's your motion. I'll hear from you.
Your Honor, we are moving to amend the information with respect to one word in the entire document. We're asking to change the location of count 76. The information reads, as it reads right now, it reads at Frame Park. We're asking to change that to near Frame Park. We believe that that's a more consistent statement that aligns with the testimony of victim PPP, Erica Patterson, as she testified in this trial. We're not asking to change any criminal charges. We're not asking to change any dates. It's, I think, a very small change in the charging document.
There were originally 2 charges associated with this one party. And these charges have been charged for the better part of a year. I feel that if there was essentially one word that needed to be changed, it's been more than ample time for it to be changed. Even after one of the charges was dismissed, it could have been, that topic could have been visited at that time for it to change. I don't think changing one word at this point really has any bearing on the testimony or the actual charge. I don't understand why a motion needs to be heard about one word. Is I think kind of at this point kind of a moot point. It's been charged like this for a year basically. The language hasn't ever been referenced to being changed before yesterday. So what is the significance of this now at this point?
Thank you, sir. There is no prejudice to Mr. Brooks. It does not change the charge in any way. It is still the same offense. It's still from the same general information that was indicated in the criminal complaint. So for all of those reasons, I will grant the state's request to amend the information, and the state may file that document as soon as possible.
I have a question about that. So this same person is scheduled to testify again. What if something changes in the testimony?
I'm not going to answer that, sir. It would require me to speculate on what that situation might be and to give an advisory opinion, which I will not do.
Well, what happens if that happens?
I'm not going to answer that, sir. I can't. You're asking me to give an advisory decision. I'm not going to do that. I'm not allowed to do that, actually. Okay, so we dealt with that then.
Makes no sense.
The state has not rested yet. Will the state anticipate calling any other witnesses?
Detective Casey did testify once for the state early in the presentation of the matter. His focus at that point was largely on assisting the jury in understanding the layout of the parade route, giving background and contextual information to the jury. He then went on to describe his personal interaction with the SUV as it came through the intersection of White Rock and Main. And was essentially, that was the bulk of his testimony during his first testimony. We're seeking to recall him now. This is not unusual. It is commonly done in cases. We never excused him from his subpoena. We never asked for him to be excused from his subpoena. We always intended to recall him. We did this so that we can efficiently present the information to the jury. The types of questions we have for him now go more to the investigation itself and his role as the lead detective in this case. We're not wasting time here, but we just have a few more questions to wrap this up.
All right, any position from you, sir?
And yes, I do. And I'm gonna start with what was just said. The prosecution feels that they've been efficient in their presentation. So it seems like to me an attempt to get more questions in that could have been asked in the first place. If Your Honor recalls, Detective Casey was testifying for quite some time, to the point that we actually had to have a break before I can cross-examine Detective Casey, if you recall. He was up there quite some time. What would be the significance at this point? When it's essentially, I should be already presenting my defense at this point in trial. I don't see the relevancy of it, and to my knowledge, he was excused from his subpoena. So,
Thank you, sir.
relevancy.
Thank you, sir. I am going to allow Detective Casey to be recalled for the reasons laid out by the state, and we'll have that done, obviously, when the jury is brought out. Any other preliminary issues then?
Really quick, I did look over some information provided by the prosecution as far as the pretrial offer that I did not have knowledge of until, I don't know if that was today, Thursday. I don't know if that was Monday or Friday or Monday, one of those days. I'll put together, started to, I won't say it's completed, that wouldn't be fair to say. I've put together, or started to put together a counter offer, so I just wanted to advise the court that I was putting that together.
All right, thank you, sir.
Your role in this case was what, sir?
Objection, leading.
Overruled.
Initially, I was on traffic control for the parade. Shortly after the incident happened, I was assigned as lead detective for the case.
Were you the individual who created this map, State's Exhibit number 15?
Yes, I did.
Okay. And I would like you to talk a little bit about how victims were identified in this case.
Objection, leading.
Overruled, foundational, the witness may answer.
So at least initially, can you tell us, like, in the day or two after the parade, what happened?
Objection, leading.
Overruled, you may answer.
As the patients came in, they were identified by detectives. The hospitals also provided us with lists of patients that they had, and we went through those lists and tried to identify people that came in and were being treated.
And then eventually, were there follow-up interviews conducted with these individuals?
Yes, there were.
What if the individual was a person under the age of 18?
Objection, leading.
Overruled, you may answer.
If the person was a minor under 18, then we would reach out to their parents, talk to the parents. Some of the kids weren't able to talk to us, but we got the majority of their statement from their parents.
Okay. And do you believe that the names on Exhibit 15 truly reflect all the injured victims that you were able to identify in the course of this investigation, sir?
Objection, statement.
No, I do not.
Hold on, there's been an objection. It's overruled, and the witness will repeat his answer.
No, I do not.
Can you explain that?
Objection, leading.
Overruled.
Just because of the scope of the investigation, we had so many people that were hurt. We had to come up with some kind of parameters to limit the people that we would call victims. One of those parameters is that they had to receive treatment at a hospital. Another one is that they had to be in the street when their injuries occurred. So there are some people that were injured, maybe on the sidewalk, trampled by the crowd, or received injuries that they didn't get hospital care from. You know, and unfortunately, I learned later on there was even a person that was in the band that somehow we missed her being reported that she received a broken leg.
We did have some spectators testify in the trial, correct?
Objection, leading.
Overruled, foundational.
Correct, but they were more in the roadway or on the curb, not on the sidewalk, or not running away from the incident when it happened.
I see. So if a person were injured because they were trampled by the crowd, are they on this map?
We exclude those.
Overruled, the detective may answer.
Those people were excluded from the map.
There were some people like that, right?
Yes, they were.
Okay.
Please make
Sorry.
sure. Thank you. I'll allow his answer to stand. Next question.
All right. I'd like to put up for you Exhibit number 32. We are going to publish this, Your Honor.
Go ahead. Permission granted.
Okay, thank you.
I don't have it on my
my screen.
It may take a second, hold on. Anything? Yeah? You can see it on the screen though, right, sir? There's a screen, obviously, on the far side of the courtroom and then to your right.
It's always better on here because
I understand, we'll get our tech guy over here to look at it, but it's previously been received and we can see it on the 2 other monitors. So for now, we're gonna continue.
Specifically as to the extreme dance team. We heard testimony about several of the girls on the team being struck and injured. Do you remember that testimony, sir?
Yes, I do.
Overruled, it's foundational. The answer may stand.
Do you know if there were other people associated with the extreme dance team that were injured?
objection speculative.
Overruled, he may answer.
Yes, I do.
And do you know the names of these people?
Objection, hearsay.
Overruled, he may answer.
Yes, I do.
What were their names, please?
Kathleen Pellmeyer,
Speculation.
Overruled, he may answer.
Go ahead, sir.
Kathleen Pellmeyer, Jennifer Stover, and Mitchell Lampine.
What was their role with the dance team?
Jennifer and Kathleen were support people. Jennifer's daughter was marching the parade. And then Mitchell was there to hand out candy with his stepmom.
Okay. I'm gonna now play, it's still not being displayed on our tables, Your Honor, but it is displayed on the 2 large monitors in the courtroom.
How long is the exhibit?
Looks like it's 1:23 according to what I can see on my monitor.
Definitely.
It is 1:23 total. We're only playing this 12-second clip from 35 to 47.
Thank you.
Do you see any of the individuals you were just testifying about enter the screen, sir?
Objection speculative.
Overruled, he may answer.
Yes, I do.
Could you identify them by using the touch screen?
Objection leading.
Overruled, he may answer.
It has 2 individuals, has Jennifer and Kathleen. Kathleen has the red jacket on, and directly to her left would be Jennifer in the black jacket.
Okay. A little hard to see right now, but as they
Very hard to see.
Keep going.
could you see 2 people walking there, sir?
Yes, ma'am.
Okay. And pause. And I'm sorry, because I can't see the counter, Your Honor.
It is at 44 seconds.
44 seconds. Thank you. Paused at 44. Do you see anybody else that you just testified to in the video at this point, sir?
Objection speculation.
Overruled, he may answer.
Yes, I do.
And who is that?
Leading. Objection.
Overruled.
Mitchell Lampine.
Please circle Mitchell. Do you know Mitchell's approximate age?
Objection speculative.
Overruled.
I believe he's about 10.
Okay. This video goes on to show the red SUV drive through the extreme dance team, correct?
Objection leading.
It's foundational here.
Overruled, it's foundational, it's previously been received. Go ahead.
Yes, it does.
To your knowledge of this video, sir, did those individuals, Mitchell and Ms. Stover and Ms. Pellmeyer, remain along the left side of the road there as the SUV went through?
Objection leading.
Overruled, the witness may answer.
They were hit by the vehicle and then moved to the left.
What do you say to this one?
This is 55.
All right, it's on. Very good. We're up and working. And 55's previously been received, so go ahead.
All right.
Objection to the relevancy of 55.
Noted. Overruled.
Can you see at the end of the road there, or the top of the screen, what unit is involved in Exhibit 55, please?
Yes.
Please tell us.
Objection leading.
Overruled.
It is the dancing grannies that are approaching from the right.
One of the dancers we have heard testimony that was involved with the grannies was a woman by the name of Lola Hospital. Is that correct?
Objection leading.
Overruled, it's foundational, the witness may answer.
Yes, she was.
Is there video showing Ms. Hospital being struck by the SUV?
Objection leading.
Sustained as to the form of the question. Please rephrase.
Sure. Is the exhibit, you've seen exhibit 55 before?
Yes, I have.
Are you able to identify Ms. Hospital, I'm sorry, yes, Lola Hospital in exhibit 55, sir?
Objection leading.
Overruled.
Yes, I am.
Please describe for the jury what you just saw in the video, sir.
Objection leading.
Overruled.
I saw the red SUV driving westbound on Main Street, approaching the Dancing Grannies and hitting Lola Hospital and then striking 2 other Dancing Grannies.
When you say hitting Lola Hospital, what did you see?
Objection leading.
Overruled. You may answer.
I saw the left side of the car come in contact with her, and then her body moved to her left after.
Did Ms. Hospital report any injuries to the Waukesha Police Department?
Objection leading.
Overruled. The witness may answer.
Yes, she did.
All right, sir. I'd like to now ask that Exhibit 118 be published for the jury. This has previously been admitted.
Permission granted.
Objection to the relevancy of 118.
It's previously been received. Go ahead.
In addition to the photograph, if you had an opportunity to examine that item or items
Objection leading.
personally,
Overruled. The witness may answer.
Yes, I have.
and Mr. Johnson from the crime lab testified about these items yesterday, but I'd like you to tell the jury what you remember of these items, please.
Objection leading. Affirmative. The first part of the question.
Overruled. The witness may answer.
So this is the red SUV that was used in the parade attack. This is a picture of it taken after. I remember a hood from a white jacket and a hat, a black hat with snowflakes on it, being pressed in between the hood and the windshield wiper of the vehicle.
Objection to it being called an attack. I think that's a disparaging remark for the record.
Your objection is noted, and the answer will stand.
When you saw these items on the hood of the red SUV, did you later come to recognize where they may have come from?
Objection leading.
Overruled. The witness may answer.
Yes, I did.
What did you determine?
I determined that they were the jacket, hood, and hats that Virginia Sorensen was wearing while she was walking in the parade.
What do you see in Exhibit 177?
Objection leading.
Overruled.
I see 2 dancing grannies carrying a Milwaukee Dancing Granny sign, and the woman on the left is Virginia Sorensen, and she's wearing a black hat with snowflakes, wearing a white jacket with a hood on it.
Move to admit 177 and permission to publish, Your Honor.
Objection to relevancy.
The objection is overruled. Exhibit 177 is received. Permission to publish is granted.
Please circle Virginia Sorensen and the hat in this picture.
Objection leading.
Overruled.
That is Virginia, and then this would be the hat and hood that I believe was found on the SUV.
There were many videos that have been shown to this jury, correct?
Objection leading.
It's foundational, Your Honor.
Overruled. The witness may answer.
Yes, there has been.
To your knowledge, are there any videos that display the license plate of the red SUV as it goes along the parade route?
Objection leading.
Overruled.
Yes, there are.
Describe what you see in Exhibit 150.
Objection leading.
Overruled.
I see the red SUV that was driven through the parade route, and it's at the time when it was contacting the Waukesha South band members. In that photo, you can read the license plate number.
Objection. How does this go to investigation?
Overruled.
Investigation.
Exhibit 150 is received. Permission to publish is granted.
Point out the license plates in the photo and read it for the jury.
It's okay if I circle it?
Yes.
Overruled. You may do so.
That is the license plate number, and I read ADP 9256.
Move to admit 151 and permission to publish, Your Honor.
Objection to relevancy.
Exhibit 151 is received. Permission to publish granted. The objections noted and overruled.
I recall this station had 140 exhibits. How did we get this many?
Keep going, Attorney Younger.
Please circle the license plate and read it for the jury.
Objection leading.
Overruled.
ADP 9256.
Detective Casey, during your investigation, did you uncover any other videos linking Mr. Brooks to this same vehicle with this same license plate?
Objection. I don't consent to being called their name and it's leading the witness.
Overruled as to both counts. You may answer.
Yes, we have.
Could you describe this video for us, please?
Objection leading.
Overruled.
There's a video that we obtained from social media that shows Mr. Brooks standing next to the SUV, and you can clearly see the license plate number on the vehicle.
Please identify 175.
This is a
relevancy.
Overruled. You may answer.
This is a photo. There's two individuals in the photo. The individual on the left, I know to be the person referred to as Darrell Brooks. It displays a vehicle, a red Ford, and it has the license plate number, which is displayed in the photo.
What is the source of this photo?
Objection leading.
Overruled. The witness may answer.
We obtained it through social media.
Okay. I mean, this is a photo versus a video.
This is the photo taken from
Hold on.
the video.
I understand the objection. It's sustained. It's foundational. This particular question, the witness may answer. Go ahead.
This is a
Overruled or sustained?
Overruled.
You said sustained.
What did I say?
Yes, you did.
Sorry. I meant it's overruled. The witness may answer. Sorry. I'm taking notes. I was writing the word source, and I think that's why I did that. In any event, go ahead and answer. Sorry about that for any confusion I may have caused.
This is a screenshot taken from a video.
Move to admit 175 and permission to publish, Your Honor.
Objection to that. What's the relevancy? I don't see the alleged defendant in here.
Your objection is noted. It is overruled, and Exhibit 175 is received.
Detective Casey, is person you know as Darrell Brooks in this photograph?
Objection. I don't consent to being called their name and leading the witness.
Overruled. The witness may answer.
Yes, he is.
How do you know that's Darrell Brooks there? His back is to us.
Objection leading.
Overruled.
I've watched the video in its entirety and I've seen his face.
How many videos do you think were collected by the Waukesha Police Department during this investigation?
Objection speculative.
Overruled. You may answer.
We have at least 65 to 75 files. Some of those files contain multiple videos, photos, could be 10 each. So I would say probably 300 to 400 videos we've collected.
Were all of the videos that were available shown to this jury?
No, they were not.
Objection leading.
Overruled. You may answer.
No, they were not.
Have you personally observed and reviewed each of the video files available in this case, sir?
Objection speculative.
Overruled. You may answer.
Yes, I have.
To your knowledge, sir, did any video ever show a different person behind the driver's wheel of that red SUV?
Objection, leading.
Overruled, the witness may answer.
I have never seen anyone driving the vehicle besides the defendant in any of the videos that I looked at.
In any of the videos, were you ever able to see multiple people inside the vehicle?
Objection is speculative.
Overruled, the witness may answer.
None of the videos that we had looked at showed anyone else in the vehicle.
Any of the videos at any point show the red SUV coming to a stop, a complete stop along the parade route?
Objection, leading is speculative.
Overruled, the witness may answer.
I've never seen a video that shows the vehicle slowing or stopping while it was on the parade route.
Do any of the videos show the driver of the vehicle exit the vehicle to check on a person who had just been struck by the vehicle?
Objection, leading.
Overruled, the witness may answer.
I never observed in the videos the driver of the vehicle to stop and check or exit the vehicle on anyone.
There was testimony earlier in this case about witnesses observing multiple people running from the car. Do you remember that?
Objection, leading.
Overruled, the witness may answer.
Yes, I remember that.
When the vehicle was found on Maple Street, you weren't there.
Correct.
Leading.
Overruled, his answer may stand.
Do you know what police activity occurred when the vehicle was found on Maple?
Objection, speculative. You just stated he wasn't there.
Overruled, the witness may answer. He was asked, what does he know?
Yes, I do.
Please tell the jury what happened when the SUV was found on Maple.
Objection, leading.
Overruled, the witness may answer.
There was an initial report that saw some other people running from the area of the vehicle. After that information was given back to us, we sent detectives down to the area to investigate further to see if we could corroborate and find out if that was true or not.
After that investigation, did you have other suspects or just one person?
Objection, leading.
Overruled, the witness may answer.
Based on the information of what everybody saw on the parade route, and then the detectives that went back down to Maple Avenue where it interviewed the people that reported the people running, our investigation determined that there was only one person in the vehicle and there was no other suspects that we were looking for.
At some point in your investigation, Detective Casey, were you given a Ford key?
Objection, leading.
Overruled, the witness may answer.
Yes, I was.
What was your understanding as to the source of that key?
My understanding that key was taken from Mr. Brooks when he was taken into custody and turned over to Detective Stern and Detective Carpenter.
Objection, I don't consent to being called that name for the record.
Noted, overruled.
How did you get it?
Objection, leading.
Overruled, the witness may answer.
You just stated how you got it.
Overruled, he may answer.
Detective Stern brought me the key the morning after the incident.
Did you do anything with the key?
Yes, I did.
Tell the jury what you did, please.
Objection, leading.
Overruled.
At that point, the vehicle was at the Waukesha County Sheriff's Department Secure Storage Facility. I took the key with me and I checked the vehicle to see if the key would work in the car.
What did you find?
Objection, leading.
Overruled.
I found that the key worked the door locks to unlock the car. I also put the key in the ignition and it turned the ignition lock.
Detective Casey, you've heard testimony about the manner in which the defendant was identified by the name of Darrell Brooks. Do you recall that testimony, sir?
Objection, I don't consent to being called that name. He's leading the witness.
Overruled. Foundational. The witness may answer.
Yes, I do.
Did you endeavor to verify the identification of the subject you had arrested for this incident?
Objection, leading.
Overruled.
Yes, I have.
Did you verify his identity by the name of Darrell Brooks?
Objection, I don't consent to being called that name. Leading.
Overruled. The witness may answer.
Yes, I have.
How did you do that?
Objection, leading.
Overruled.
There were a couple different ways. We take the fingerprints, we check that against other records that are kept by the state. Those fingerprints matched Darrell Brooks. I've also spoken to 3 women that he has children with. They verified that is his name that he has always gone by. I have also spoken to his mother, which states that that's the name that he has gone by always.
I'd like to put on the screen for the witness only Exhibit 88. Do you see Exhibit 88, sir?
Yes, I do.
Objection to this, what was the relevancy?
Overruled. Go ahead.
Grounds for overruled.
Relevant.
In what way is it relevant?
To the counts alleged in this case. Go ahead.
Can you please identify Exhibit 88, sir?
This is a bail bond through Milwaukee County Circuit Court for Darrell Edward Brooks, the date of birth of 2/21/82.
To your knowledge, was Mr. Brooks on bail through a Milwaukee County case on the date of November 21, 2021?
Objection, leading.
Overruled. The witness may answer.
Yes, he was.
And what is the date of this bail form? Please, believe it's near the bottom.
The date on the bottom
Objection,
is
leading.
Overruled. The witness may answer.
2/21 of 2021.
By classification, can you tell us the level of charges that Mr. Brooks was pending on for this bail?
Objection. You've already made a ruling on it.
Overruled. The witness may answer.
All the charges that I see in here are felonies.
To your knowledge, was this bail in full force and effect on November 21 of 2021, sir?
Objection.
Overruled. You may answer.
Yes, it was.
And in the middle of the form, do you see the conditions of bail that were set upon Mr. Brooks?
Objection, leading.
Overruled.
Yes, I do.
Could you please read that bail condition to the jury?
Objection, leading.
Overruled. The witness may answer.
The state defendant shall not commit any crime.
Thank you. Move to admit number 88, Your Honor.
Objection.
Exhibit 88 is received.
I'd like to display for
Already
the,
speculated to. How's that coming into evidence?
Overruled. And permission to publish.
I'm sorry, I did not seek to publish this, Your
Oh,
Honor.
all right. Turn that
I
off.
request a legal finding of fact for that.
The objection is noted. It's overruled. Continue. Attorney Opper.
Thank you. I'd like to display for the witness only Exhibit 89.
Go ahead.
Sir, can you please identify 89?
Objection.
Overruled.
Relevancy.
Overruled.
This is
This has been stipulated to as well. How's it evidence? How's it being admitted?
The objection's noted. It's overruled. The witness may answer.
I request a legal finding of fact for that too, Your Honor.
Noted. Overruled. Go ahead.
This is a bail bond through Milwaukee County Circuit Court for Darrell Edward Brooks with the date of birth of 2/21 of 1982.
Is this a different case than what was displayed in Exhibit 88?
Objection, leading.
Overruled.
Yes, it is.
Are you able to make any observations about the level of charges related to this case, sir?
Objection, leading.
Overruled.
It appears that there's 4 charges, 2 of which are felonies.
Okay. And on the bottom of the form, can you tell the date that this bail was issued?
Objection, leading.
Overruled.
States 11/11 of 2021.
Could you please read the conditions of release that were set by the court in that case?
Objection, leading.
Overruled. The witness may answer.
Defendant shall not commit any crime.
To your knowledge, sir, was this bail in full force and effect on November 21 of 21?
Objection, speculative and leading.
Overruled as to both. The witness may answer.
Yes, it was.
I'd like to display for the witness only, Exhibit 13.
Objection, what's the relevancy of this? How does it say any foundation to testimony?
I'll give the state some leeway to establish that. Go ahead.
Can you tell if Exhibit 13 is a video, sir?
Yes, it is.
Okay. Have you seen this video before, sir?
Objection, leading.
Overruled.
Still relevancy. Where's relevancy?
The state is asking the foundational questions. The objection's a bit premature. I'll take it under advisement. Go ahead, Attorney Opper.
Yes, I have.
What does this video depict?
Objection, leading.
Overruled. The witness may answer.
Objection, speculative.
Overruled. Go ahead.
This video depicts the backyard at 4014 North 19th Street in the city of Milwaukee. It also, that's the address of Dawn Woods, the mother of Darrell Brooks. And on the lower left-hand corner, you can see a Ford Escape.
In the lower right.
I move to strike that. How does he know? What?
The objection's noted. Overruled. You can ask him on cross-examination. You can question him about that. Go ahead.
In the bottom right-hand corner of the exhibit, do you see a date and time stamp for this video, sir?
Objection, leading.
Overruled.
Yes, I do.
What does it say?
It says 11/21-2021, and then it says 13:26:18.
What do those numbers represent, sir?
Objection, leading.
Overruled.
To me, it means that the video was taken on November 21st, 2021 at 1:26 p.m.
How did you come into possession of this video, sir?
The defendant's mother provided it to us.
And do you know approximately when it was obtained?
Objection, speculative.
Overruled.
The evening of November 21st, 2021.
Do you know if the defendant's mother was cooperative with police in providing the video?
Objection, relevancy.
Overruled. The witness may answer.
Yes, she was.
Do you know if the video was provided to police when asked?
Objection, leading.
Overruled.
Yes, it was.
Move to admit 13, Your Honor, and permission to publish.
Objection. Where's relevancy?
Noted. Overruled. Exhibit 13 is received. Permission to publish is granted.
For the record, this is a video. It's 49 seconds in duration. We're going to play it in full. There is no audio.
If the jurors would let me know when the monitors are displaying the video.
Did you see any damage to the front end of that vehicle as it drove away?
Objection, leading.
Overruled.
I did not.
What is the source of Exhibit 14?
This is a still shot taken from the video.
The The same video we just saw, number 13.
Yes.
Okay. Move to admit 14 and permission to publish, Your Honor.
Objection, relevancy.
The objection's overruled. Exhibit 14 is received. Permission to publish is granted.
Sir, do you see Darrell Brooks in this photograph?
Objection, I don't consent to being called that name again for the record.
Noted. Overruled.
Yes, I do.
Can you identify or, describe the clothing items that you see him wearing in this photograph? Oh, it's not in the jury box yet, I'm sorry.
You can state your objection, though.
Leading.
Overruled. The witness may answer.
Mr. Brooks is wearing a red t-shirt, blue jeans, and he has blue colored flip-flops on with white socks.
What's the date and time stamp for this photograph, please?
It's 11/21/2021 at 13:26:08 hours.
And that's what time, sir?
Objection, leading.
On the 12-hour clock.
Objection, leading.
Overruled.
That would be 1:26 p.m.
All right, thank you. Any other questions, sir?
In the two exhibits we just watched, 13 and 14, do you see anyone driving the vehicle?
No, I do not.
Do you know if anyone's in the vehicle at the time that you see it pull away?
I would assume based on my training experience that when the vehicle pulled away that there was someone inside the vehicle, because in order to move a vehicle you have to manipulate the controls, the shifter, the brake, the accelerator. So my assumption is that someone is inside the vehicle doing that.
That wasn't the question. Do you see anyone in the vehicle?
I object, Your Honor, that was the question, and he's already asked and answered. The question is, anyone can be seen.
The objections, not sure what the objection was, but the answer may stand. You can ask your next question.
Let's go back to exhibit 175 and pull that up for the witness.
Would the state please pull that up? Witness only or published?
Published.
Okay, thank you. All right, go ahead. It's in the jury
You
box.
just testified that this was the alleged defendant. How do you know that? Can you see a face?
Which question are you asking? Those were two.
Can you see the face on the circled individual in that exhibit?
In this clip, I cannot see the face of the person that is circled.
So how do you know who it is?
I can tell who that is because I have watched this video in its entirety, and I can tell that it is you based on all of my contacts with you.
So why were there not any other exhibits that can give credibility to you positively identifying the individual in this video?
Objection, argumentative,
Grounds.
compound.
Sustained.
Is it fair to say that this is the only exhibit photo from the video?
Can you clarify the only one that is shown today, or the only one that has ever been taken?
The only one that's,
ever
the only
exists?
one that's
Be clarified,
being
please.
shown right here today. Is this the only one that is an exhibit being shown here today?
Yes, this is only. one that we've shown today.
And you can tell just from this